Good afternoon and welcome to the Appellate Division First Department. We'll begin with the call of the calendar. Please know I have 7 hours of requested argument time. So please limit your requests to the time that you need, not the time that you want, understanding that the time is for you, not for my colleagues. So if you are brilliant in your argument and they have more questions, I let the time roll. That said, People versus Xavier Rivera. Okay. How much? 5 and 1 and 5. Huns versus Jones. Okay. 5 and 1 and 4. Tawana versus Darish is a submit. Rodriguez versus Madison Security Group. Okay. 5 and 1 and 5. Lechner versus 20554 House. The appellant. Who's the appellant? She is. How much time? No. How much time? You don't need 15 minutes. Give me a reduced time or I will do it for you, ma'am. Okay, how much? 5 and 1 and 5. People versus Frederick White. Okay. 7 and 2 and 7. Gilbert versus Powers. Okay. 4 and 1 and 4. Alvisurus versus North State Realty, and I'm sorry if I mangled the name. Appellant? Okay, 2 minutes it is. Serrano versus Judla Contracting. Okay. 5 and 2 and 5. B. Andrew versus Algra J. You have no opponent, so I'm going to give you 3. Thank you. You're welcome. AEB Fund versus Duval and Stachenfeld. 5 and 1 and 5. People versus Darnell Wint. Submitted. Panza versus RXR Church Division Tower. Okay. 4 and 2 and 4. Park versus Sakosa. Okay. 5 and 1 and 4. Wagner versus Wagner. Okay. Okay, let's do 5 and 2 and 5. Rooney versus Board of Managers. Okay. 5 and 2 and 6. People versus Crystal Hudson. Submitted. Richmond Global Compass versus Nacimiento is submitted. First case on the calendar, People versus Xavier Rivera. You may proceed.
Good afternoon, and may it please the court. Nusiba Hamad for Mr. Xavier Rivera. The evidence must be suppressed and Mr. Rivera's conviction vacated on 2 separate bases. First, the MRTA applied to the post-enactment suppression hearing in his case, which means that the court's determination that the stop and search were lawful solely on the smell of marijuana cannot stand. Second,
That wasn't the sole basis, was it?
it was, Your Honor.
Wasn't he double parked?
The court did not find.
Was he double parked?
No, Your Honor. He was actively parking at the time.
Okay, so if the court believed the officer's testimony that he was double parked and that was a violation of law, wasn't that sufficient basis for an approach?
It may have been a sufficient basis
No,
for an
isn't
approach.
it? When someone is double parked, under the law,
Yes,
doesn't that create a absolute basis for the police to approach that vehicle?
It does, and the suppression court on page 7 of its decision ruled explicitly that the smell of marijuana emanating from the gray hatchback gave the police reasonable suspicion of criminal activity justifying a level 3 stop.
So this case, to sort of get to the chase, presents a really interesting issue that's been dealt with by the second and third departments, but not by us, right?
Correct.
And where the incident, the arrest happened pre the enactment of the new law, but the hearing was post-enactment.
Correct.
And there's been different findings on that. So, I mean, I know which way you're arguing it, but could you, elucidate us on that a little bit, because it's a new issue, and I think it's going to the Court of Appeals, right?
Yes, it is pending in the Court of Appeals at this time. And what we have here is the MRTA, the plain text of the statute, effective March 31st, 2021, plainly says that there is a ban on judicial determinations and findings of probable cause based solely on the smell of marijuana, and it specifically covers
But that particular statute has been held by the Court of Appeals to not be retroactive, isn't that correct?
No, Your Honor. In Pastrana, it was a different procedural posture, and Pastrana also explicitly left open this question of pre-enactment search, post-enactment hearing. And Pastrana was dealing with a very specific question, which was whether the MRTA applied for the first time on direct appeal in an already otherwise final conviction. And so what we have in the statute is the legislature contemplating exactly this type of scenario. They were very clear in the language. They said on this effective date, this is the law that applies in criminal proceedings.
And the search happened before the
Yes, the search did happen before.
Pastrana says no retroactivity. But you're saying because the hearing on the search happened after the statute, that we should somehow change the non-retroactive, because essentially we would be saying it's retroactive to a search that occurred prior to the enactment of the statute.
This is actually not a question of retroactivity because, again, the plain text of the statute.
Except that the officers who were acting on the day of the arrest were acting on the basis of the law that was in effect at the time. So to now evaluate that on the basis of a new standard, that seems like a retroactive application of the law.
If the MRTA applied to police conduct and not judicial determinations by its plain text, then that would be true. But the MRTA in Subdivision 3 specifically says judicial findings and determinations. And there is no retroactivity implicated when the legislature in this case wanted not necessarily to regulate police conduct, but to stop giving a judicial stamp of approval to marijuana-only based searches. They explicitly address this scenario in the plain text, and their effective date and the language that they used.
So the second department has said that the effective date is when the search occurs, because that's the date that the officers are knowing what the law is at that point, right? They can't know on the date of the search that in the future, this will no longer constitute cause for,
Right.
Right?
And
Or reasonable suspicion will be. So why is that wrong?
Well, the second department did get it wrong. They relied incorrectly on Pastrana and their own prior rulings, which also relied on Pastrana. And at the end of the day, Your Honors, all we have to do is read the plain text of the statute. It specifically impacts only judicial findings and determinations. It is not trying to regulate police conduct.
It's asking judges to pretend like what the officer did on the day in question was inappropriate on that day, and it wasn't. So it's asking us to declare that what the officer did was improper, when at the time he did it, it wasn't improper. So I have a problem with that, but you'll have time on rebuttal.
Thank you.
May it please the court, Charles Wan for the respondent. Your Honor, it would be illogical to hold that a suppression hearing should suppress evidence that was obtained from a valid legal search only because of when the hearing was held.
So in Pastrana, the Court of Appeals says that applying it retroactively would not, the conduct that's sought to be deterred is police misconduct. But if the conduct already happens at a time when it's perfectly legal to make a stop based on the smell of marijuana, that's not going to deter conduct, right? Because we're looking back, not forward.
That's correct, Your
So
Honor.
Pastrana seems to me directly on point with respect to whether or not we would apply this, because the stop happened when it was legal to do it, and there's nothing that in the statute is intended to prospectively stop police misconduct, right?
Yes, Your Honor. I mean, that is the purpose, actually, of the suppression hearings in the first place. And that's what the Court of Appeals discussed in Pastrana, that the purpose is to, deter police misconduct. And as Your Honor pointed out, here, the search was valid. Police did not do anything wrong. So in actually saying,
At the time, as
at the
with the
time,
law,
yes, Your
right?
Honor. At the time, police were acting under the law, which was they can't.
And
Which is how-
am I incorrect that the officer here testified that this was a double parked car? So that with or without the smell of marijuana, they would have been entitled to approach this vehicle?
Yes, Your Honor. The police were actually responding to a reports of a shots being fired.
I know that.
And at the scene, defendant was the only person in the area, and his vehicle was double parked. He did park it by the time the police turned around and came back, but at the time, it was double parked, and as the police drove by, he smelled odor of marijuana coming from the vehicle, and when they came back, he admitted he had marijuana, and under other circumstances, the police had probable cause to search the vehicle, and it was all valid at the time. So there is no reason for the to hold at the suppression hearing.
I think she
So counsel, I thought indicated that the Court of Appeals in some way left open this arrest pre-enactment but post-enactment suppression hearing issue. Did they somehow leave, I mean, I know that they've agreed to hear that issue in the Court of Appeals, but did they leave that open in the Pastrana decision?
They did say they're not addressing it in a footnote, but based on their decision, it would naturally flow that they would hold that it is the date of the search that matters, because they discuss about how the purpose of it is not to deter police misconduct, which we all pointed out that it was valid at the time, and the court point also talked about how that the legislature did not intend for convictions to be vacated all because of when the search occurred. That it was, as long as it was valid at the time, it should not be suppressed. So for those reasons, defendant's conviction should be affirmed. If there are no further questions.
I just want to ask you about, assuming that we agree with you, would you, I think the defendant argues there's no way this police officer smelled marijuana driving by. And how would you respond to that?
Well, the hearing court found the officer credible. So there's no reason to doubt the hearing court's credibility. I mean, the hearing court heard the officer testify, so there's no reason to doubt the hearing court's credibility determination in this case. Thank you, Your Honor.
So if I may, I want to get through 2 points very quickly. The first is that the body cam in this case clearly contradicts the officer's testimony at multiple points, as I laid out on both in my opening brief and on page 9 of my reply. Second of all, deterrence really is not at issue here. First, there is a limited number of cases that are pre-enactment search, post-enactment suppression hearing.
Well, I mean, but isn't that exactly what the Pastrana, the Court of Appeals said in Pastrana is the purpose of the statute, is to deter police misconduct by basing every single search and on every single automobile stop or every stop on the smell of marijuana, which the Court of Appeals and I think the legislature thought was not an appropriate basis. Isn't that the whole point of the statute?
No, the statute, Your Honor, is remedial, and deterrence is a Fourth Amendment question, of course, and what we have here is a legislative decision about whether the legislature wanted courts to give a rubber stamp, a judicial stamp of approval to marijuana-only searches. The legislature clearly addressed this precise scenario by giving an effective date and then saying that it applied to criminal proceedings. The statute really could not be more clear in its plain text, and I see that I'm out of time.
You can finish your thought.
Thank you. And just separately, there was no probable cause here to believe that even aside from the MRTA, Mr. Rivera possessed more than 2 ounces of marijuana, which would have been a criminalized amount in 2020. He needed to have more than 2 ounces. That's a really substantial amount, and not a single case that the prosecution cites supports a inference or even a probable, especially not a probable cause finding based on only the smell. There has always been more. There always needs to be more. And in this case, Mr. Rivera's conviction, there are simply no grounds on which to uphold it, and so we ask the court to suppress the evidence and vacate.
Thank you. Thank you. Huns versus Jones. You may proceed.
May it please the court. My name is Naomi Weinstein, and I represent appellant Raphael Jones. This case is admittedly moot, but there is an important question of law, which is whether someone can be subject to a treatment over objection order where there's no evidence whatsoever about any side effects, and the order allows for unlimited and unnamed medications and tests to address these side effects. Rivers made it very clear that there's 2 parts to any treatment over objection order, which is first, whether someone has capacity, and second, whether the order is narrowly tailored to give substantive effect to Mr. Jones's due process rights.
So on the issue of capacity, your client has no insight into his mental illness. Seems like they met that burden.
Your Honor, Mr. Jones does deny having a mental illness, but as the court in Rivers made clear, having a mental illness alone is not justification enough to support a finding or an order to treat someone over their objection. Here, it was understandable.
You said there were 2 things that needed to be met, and my statement to you is that first one is met.
Well, Your Honor, we respectfully disagree on that point, but
Why?
in this specific case, because Mr. Jones, it was admitted by the doctor, the expert at the hospital, that he's had 4 different diagnoses, and
So what?
and so
Psychiatry, you can also go to different doctors, and one will say you have one thing, the other one will think it's something else. That is not a basis to discredit their finding.
So even arguably, if he does lack capacity, if this court finds he has no insight, again, it's the second prong that we really truly believe that this court should rule on, even though he's since been found fit and discharged from the hospital, which is that there was absolutely no testimony whatsoever about any risks. And so how could the court possibly make a reasoned decision weighing those risks and benefits when those were never tested?
Well, didn't the treating psychiatrist say, I've looked at this issue, that the risks, the benefits outweigh the risks?
She did testify.
So there's that testimony. It was up to mental hygiene to cross-examine if you wanted. She made an opinion based on her, I think she was the treating psychiatrist, and she said, this is based on my opinion, this is the least restrictive alternative with the least, I mean, she absolutely
And at the
put
time,
that in.
the client was being violent with staff, so they needed to do something.
Your Honor, there was no testimony that he was violent with staff. There was testimony that he received a stat medication for getting agitated, but he was, as is clear from the transcript, able to sit appropriately through the hearing. And regarding the doctor's conclusory statement, she merely stated that all medications have side effects. She never testified about any specific.
That's up to you to cross-examine her. If you were unhappy, if you didn't think that I mean, the testimony meets the standard. Your objection is that it wasn't elucidated on, but that's up to the cross-examiner to do.
But it's not just, respectfully, Your Honor, it's not just cross-examination. It's the hospital's burden to show by clear and convincing evidence that the risks outweigh the benefits. Not for the doctor merely to say, sure, all medications have side effects. We don't know what we're going to treat with them. We're going to have unnamed, unlimited medications.
That is not what the doctor said. They started with, I think, risperidone, right? And then they were talking about the shot because he won't take the pills. And So the doctor listed the medications that she intended to do, except she switched the order during the testimony, but she still had the long-acting one. She went through every single medication, or she went through the medications, plus the documents in evidence went through the medications, right?
Your Honor, there was nothing in evidence. The hospital attempted to put in the medical record. We objected to that. The court never admitted the medical records. The pleadings were never entered into evidence. No evaluations were entered into evidence.
Oh, there was testimony to all of that, right?
Well, respectfully, Your Honor, Dr. Paris testified first that the proposed order was completely incorrect. She had to switch the order. The proposed order said risperidone first, Zyprexa second. She had to switch that in the middle of her testimony. Secondly, she never testified as to the paliperidone. There was absolutely no testimony on that, or the Haldol, which were alternative medications. And again, the order allows for all necessary medications to counteract possible side effects and laboratory tests to monitor efficacy of medications. There was no testimony what those medications would be.
Was there any indication in any of the medical records that your client had suffered any ill side effects from the medications that they were prescribing for him?
That did not specifically come up, but how would we to know? We don't even know what exact medications they would be offering, whether he's ever been offered it before.
Got a proposed order, right?
Yes, Your Honor.
So you did know what they were seeking.
Well, we knew, but again, Your Honor, other appellate divisions have held this is not enough. They've reversed on very similar cases. For example, in Radcliffe M, striking medications where the petitioner failed to offer any testimony or evidence at the hearing. Lucas QQ, because there was no clear and convincing evidence in the record about narrowly tailoring the order to Mr. Jones specifically. Samuel D, striking medications where minimal evidence was presented at hearing. These hearings cannot, and I see my time is up, cannot just be rubber stamps, Your Honor. And at the very minimum, it requires some showing of the risks that Mr. Jones could potentially have, whether or not he's experienced it in the past. We don't know if he's ever taken these medications in the past, other than the olanzapine, which Dr. Paris testified, and therefore we ask that this order be reversed. Thank you.
May it please the court, Danny Lee for Kirby Forensic Psychiatric Center. It's undisputed that appellant's discharge from Kirby renders this appeal academic. Therefore, this court can and should dismiss the case as moot. In any event, if the court were to—
Are you suggesting that there's never a possibility that this gentleman will decompensate and not end up back at Kirby?
That's possible, but this—
So then it's not moot.
We think the case is moot because it doesn't present any substantial and novel—
All right, well, why don't you address the substance of it in case we disagree with you? I suggest very strongly you do that.
Definitely, and we
Okay.
think that opposing counsel's argument highlights why the issues aren't substantial and novel, because all the arguments are standard prong 1 and 2 analysis, standard prong 1 and 2 objections. All of our arguments are record-specific arguments about why on this particular record, there's not enough evidence to show that this particular patient had the symptoms.
Well, do you disagree with your adversary that there's nothing in evidence other than testimony? Is that true?
Absolutely. We think there is ample evidence in the record.
So I looked at the doctor's testimony, and it seemed pretty general and conclusory. And there wasn't a whole lot of detail concerning, I saw nothing about what potential side effects were for any of those medications. Can you tell me where in the record she addresses that?
Yes, I can run through Dr. Paris's
Tell
testimony.
me where in the record I can find it.
So Dr. Paris didn't list every single potential side effect, but she did testify.
Did she list any side effect? Because I didn't see not one.
She didn't identify the side effects.
And is that enough? According to your colleague, that is not enough under the case law. Is she wrong?
She is wrong.
Okay.
Because Dr. Paris testified that olanzapine was chosen as the primary medication exactly because appellant had previously taken olanzapine and had not experienced any side effects. She further testified that the order itself authorizes the use of all necessary medications to account for side effects. Identical language was cited by this court in its Matter of Kuhn's decision in 2024 as proof that the order is narrowly tailored to account for side effects. So this argument that that language is overbroad has already been rejected by this court. And finally, the order itself also authorizes the use of blood work and laboratory tests to monitor treatment. In light of that, there's ample evidence in the record as to prong 2 showing that this order was narrowly tailored. And I would also mention—
Well, is that narrow to say we're going to allow for blood and diagnostic testing?
it shows that the order was designed to account for potential side effects. And this court—
I know, but if you've got a patient who doesn't want to take pills, he's gonna enjoy having blood drawn and injected all the time.
Of course not. And that's why the order has to be narrowly tailored to account for his liberty interests. There has to be a showing that he's not capable of making a reasoned decision about his medical treatment. And there's also ample evidence in the record that shows that. I would just refer the court to appellant's own testimony at the Rivers hearing, where he repeatedly denied having any mental illness, said he had no history of mental illness, and even denied ever speaking to the treating physician.
Have we ever held that it's a requirement that the treating psychiatrists go through every single medication that could possibly be given to the patient? Have we ever held that that was a requirement under Rivers? That
No,
you go
actually
through
the
every
opposite. And
single?
here I would just quote from the Matter of Kuhn's decision. The court said, "The order includes dosages and circumstances under which the alternatives would be administered," the same is true here, and, quote, "authorizes all necessary medications to counteract possible side effects. This record sufficiently supports the authorization of alternative medications." In other words, the court has already approved the exact language that the appellant now objects to. So we urge the court to affirm or to dismiss the case as moot.
Also, you have 1 minute.
Thank you, Your Honor. I just want to briefly respond. Thank you. So regarding FH, that case involved documented allergies that a patient had to medication. It did not address this broad, overbroad.
Have we ever held that the treating psychiatrist has to go through every possible medication that's listed in the treatment plan and go through in great detail or any detail every single side effects, particularly ones that are probably not going to be are not going to be given to the patient?
Not specifically, Your Honor, but Rivers talks about the considerations that the court must make about each particular drug, the risks and benefits of each particular drug, the proper lengths of its usage, and whether there's any.
That's in the order, right? That's in the prepared order that you're given.
But
that you look at.
Sure, the dosages, but there was nothing about the side effects. The fact that he's been on one medication in the past, they were asking for 4 additional medications, unknown, unlimited other medications, and we're talking about potentially serious side effects. They don't have to list every side effect. How about just list one, like, for example, tardive dyskinesia, which is a very permanent, well-known side effect of medication. There was absolutely no testimony, and therefore the order was not narrowly tailored. Thank you.
Thank you. Rodriguez versus Madison Security.
Good afternoon. May it please the court, Patrick Lawless for the defendants' appellants, Preservation Management and Casco Realty. First, I'd just like to address the timeliness of the motion. It's clear that the motion for summary judgment was timely. The 120-day deadline fell on a Saturday.
Ended on a Saturday, right?
Yep,
Yeah.
yep.
So.
As to the merits, the appellants demonstrated that, first of all, that this assault was not foreseeable, and nor they didn't have any opportunity to control the actions of the assailant or prevent this assault.
The person who committed the assault was a tenant at the building, right?
Exactly. It was assault between.
So it's
one
tenants
tenant on
against a
another.
tenant, right?
And it arose out of a personal dispute, and the
And
plaintiff.
there was never any specific complaint as to.
No, there were no prior complaints, and not only that, but the plaintiff had testified throughout her deposition that she had known this individual for a number of years, never had any
She
issue.
was a baby, 18 months.
Well, did it make any difference that she said that she complained many times to the management company, to your client, about these kids that were threatening her daughter? I mean, because this was going on for a long time.
None of this is related to this particular assault. As a matter of fact, the plaintiff testified that she had an interaction with this individual just a few hours before the assault, and it was fine, that there was some sort of disagreement between this individual and her daughter, and she just brushed it off as just kid stuff, didn't think it was worth any
Did not
attention.
believe he would attack her.
Up until the point that the attack happened, she kept on saying over and over again, I never thought this was turned physical.
And it turned out this happened at the near the security booth, right? So it was outside. It wasn't like it happened inside the building.
No, it looked like it was in a driveway near the security booth. And again, the plaintiff testified, even in the moments just up until the assault, that she never thought that it would ever turn physical or violent.
And she also acknowledged that she never complained about him being, she
No, she never made, and that's
complained
the
that
thing.
that person was violent.
Exactly. And all those other prior complaints, they were about other individuals, younger children that
They were
had issues with their
generalized.
daughter, and some unruly kids running around the parking lot, but nothing about this individual. Any other questions? I'll reserve my time on my reply.
You got it. Counsel?
Good afternoon.
Yeah, bring that down for yourself.
Good afternoon. Denise Rubin, appearing as appellate counsel to the Office of Harmon Linder and Rogowski for plaintiff Lillian Rodriguez. Let me start by saying we do not argue that the motion was untimely. It clearly was. So moving on. She made a series of complaints beginning as early as, I believe it was April or August of
So may I
2009.
start and ask you, what do you think the landlord's obligation is with respect to the other tenant?
I would argue first, Your Honor, that it's not one other tenant. He
Well,
was a
this is
group-
the,
with a
one
group
other
of
tenant
kids.
hurt her. That's the claim. So again, I'm going to ask you, this is two tenants in the building. They both have the right to be in the building. There's no question that the landlord didn't, there's nothing about the landlord keeping the property unsafe. These are two tenants who are entitled to be there. So again, I'm going to ask you, what is the landlord's duty in your view in this case?
The landlord's duty, Your Honor, is to make sure that a minor child, in this case he was still 16, who is known to run with a gang of children who are described in at least one of her memos to the management as like a wolf pack running around the complex, harassing other people.
Doing what?
spitting at-
Making sure what? That they don't hurt other people? How? How are they supposed to do that? How is the landlord supposed to do that?
Well, they might have put on a second security guard, as they had been asked to do repeatedly, not only by Ms. Rodriguez, but by the Tenants Association.
For their own tenants, not for someone outside.
Yes, absolutely. You
You're
have
saying the landlord
unsupervised-
has an obligation to police each tenant against the other?
Not each and every tenant, but a tenant known to be a problematic tenant, a tenant known to run
How
with a
about a
group of
tenant
other.
that complains a lot about the noise? Is that a problematic tenant that the landlord has to do something about?
No,
What's
not
the
in
scope
this
of the
sense.
duty?
We're
That's what I'm
talking-
trying to figure
Sorry.
out.
We're
No.
talking about security and safety. We're not talking about an annoying person who says, oh, you're too loud, you're too loud. We're talking about a group of kids who for 2 years have been harassing her daughter, have been assaulting her physically, spitting on her, throwing things at her, pulling hanks of her hair out of her head. And just because Ms. Rodriguez did not believe this one 16-year-old who ran with these kids would hurt her, Ms. Rodriguez, an
Was he
adult.
ever identified?
Pardon?
Was he ever identified as part of the group of kids?
He is not named specifically in her earlier memos.
Okay.
But the ringleader, so to say.
So how is that foreseeable? If she doesn't name him, right, as she does the other kids, how does the management company protect something they don't know about?
The management company did know about it, Your Honor.
Well, the
They
didn't the management company send out once or twice in response to your client's complaints, a memo to all the tenants, please be reminded that you have to mind your children under 16. I mean, I'm not let them run around. I think that's a little difficult, but.
Acknowledge the complaints, they acknowledge the danger.
But what are they, beyond that, beyond saying to the tenants, mind your children? I mean, if you live in a complex with 400 people and 200 of those families have several kids, you're gonna have a lot of kids running around, you're gonna have issues, right?
Sure.
So what is the management company? They're supposed to be the parent of these children who are running around in their complex?
No, but they should do something more after 2 years of complaints than sending a memo saying, oh, you're supposed to watch your kids.
What?
Maybe put in-
What?
Maybe put in a system whereby the tenant is charged a fee if the kid is in trouble again, or charged for fixing the broken, at one point they stretched the bars of the playground fence and climbed in after closing hours.
But how would that have affected the fact that this kid attacked your client? How is there a proximate cause between charging the kid's mom $100 for something the kid did and the kid attacking your client? Where's the proximate cause there?
Proximate cause is in being told you have a wolf pack full of kids running around, harassing my daughter specifically, but many other people in the complex as well. They're making trouble regularly. We've regularly complained to security.
Isn't that a police issue? The
And
landlord's
she
not
made
a police
complaint.
We don't
Also,
want our
she knew him
landlords.
since he was a baby. Why didn't she mention him by name? And giving complaints about unsupervised children, how does that put them on notice that he was going to attack her when she has acknowledged that she never said he was violent?
She acknowledged that she never thought he would attack her personally. He was part of the group that was harassing her
Did she
daughter.
give
however.
his name ever?
All right,
sorry?
we've got your, but she didn't name him.
Thank you, Judge.
I don't have anything further.
Thank you, smart man. Lechner versus 20554 House, Inc. You have 5 minutes, ma'am. You can come up.
Your Honors, I did serve the papers personally, but this was not this was a minor procedural irregularity under CPLR 2001, not a jurisdictional defect. The technical defects can be disregarded if there is no prejudice. The defendant considered actual notice, retained counsel, requested an extension, and filed a cross motion showing they could fully defend. Jurisdiction was already established via proper service of the summons and complaint, denying default elevated from over substance, especially since no prejudice occurred.
You can continue.
Okay, another question. But the trial court found prejudice because a default judgment could have been entered. Isn't it actual harm? No, Your Honors. Prejudice under CPLR 2001 means the defendant couldn't respond due to the defect, not mere risk of an adverse outcome. The defendant actively litigated, proving no inability to defend. As argued in my reply brief at page 1, confusing consequence with prejudice misapplies the law. The notice of disposition stated you get any surplus over cost, and you received $142,142.59 590.08. How does it breach and imply the contract? The actual price was $310,000. Doesn't the closing statement refute your claim? The answer, the implied contract from notice wasn't just about a mathematical surplus. It promised a commercially reasonable sale with good faith and diligence. My original $850,000 investment in a prime midtown location versus the $310,000 auction price raises a triable fact issue on reasonableness, not resolvable, on CPLR 3211A1. Documentary evidence must usually refute the claim. It doesn't here, as the sale process itself is disputed. See my opening brief at page 7. Why isn't your RPA PL 702 claim buried by res judicata from the housing court for non-payment proceeding? You could have raised it there. The res judicata doesn't apply because housing court lacks jurisdiction to award RPAPL L702 damages. It's limited to possessions and rent under NYC Civil Court Act 204. There is an exception when remedies are not fully available in the prior forum. I couldn't litigate the statutory damages there, so the claim survives. This is detailed in my reply brief at page 2 and 3. Isn't your promissory estoppel claim duplicative of the contract claim? Why should it survive dismissal? It's properly pled in the alternative as allowed when contract existence is disputed, when the defendant does. Dismissing the promissory estoppel claim prematurely ignore this, as argued in my opening brief at page 9 and reply at page 3. What relief are you seeking and why reverse the entire order? I'm asking to reverse, reinstate the complaint, and either grant default judgment or remand for proceedings. The trial court erred on all points, misapplying standards and ignored viable claims. This ensured justice as an action undervalued my shares by over $500,000.
Thank you. You'll have time on rebuttal.
May it please the court, Samuel Gorman for defendant respondent 20554 House Inc. This is my first time before the court, so don't mind the nerves.
Okay, that's all right.
So just responding to each of the appellant's points that she made. So first, the lower court properly denied the plaintiff's motion for a default judgment on the basis that the plaintiff herself violated CPLR 2103A, so that should be upheld. So it's important
By serving it herself.
by serving the papers herself. So it's important to note that the lower court actually held that they would overlook the irregularities with the service of the complaint papers themselves by the plaintiff, but they concluded that the service of the default papers, which were served 20 days after the complaint was first served on the Friday after Thanksgiving, the lower court decided that they could not overlook the irregularity there. And this is not a mere irregularity that can be overlooked, because to reverse this decision to dismiss the default judgment after the defendants have already successfully won a cross motion for to dismiss the case would result in an absurd result, because the case would just get kicked back down and then it would be decided on its merits. And the court decided that the case should be dismissed for the points that I'm going to get into in a moment. And just the last point on that first aspect, just the mere request that this motion for default should be restored as a mere irregularity is improper. Oh, and also,
Address the second issue.
yes. Turning to the second point, so the lower court did properly dismiss the plaintiff's first cause of action, which was for breach of an implied in fact contract. So the plaintiff made mention of a notice of sale letter that was sent to her to inform her that the apartment that she lived in was going to be publicly auctioned. So in that letter, it outlined the date of the auction, the amount that was owing on the apartment, and this was after a lengthy, litigation and non-payment in landlord-tenant court, which resulted in a judgment against the plaintiff. That notice of disposition of collateral informed the plaintiff of what she owed and informed her that if there were extra proceeds remaining after the money that was still owed for maintenance was taken out, that those extra proceeds would be returned to her. And that is, in fact, what happened.
That was about $131,000 in unpaid maintenance, assessments, et cetera.
Yes, so she had over $131,000 in maintenance. And it is important to note that the plaintiff did acknowledge that even though she was unhappy with the amount of extra proceeds that she received from the auction, she acknowledged receiving the check for the extra proceeds, and she actually did receive it. And then quickly turning to, and then it's important to point out that the defendants in the lower action provided documentary evidence which was sufficient to establish that the plaintiff's causes of action lacked merit. So turning to the res judicata grounds, so in the March 17th, 2025 decision, Judge Engeron decided that res judicata would bar the second cause of action. So this is the RPAPL issue that the plaintiff raised before. He decided that it was previously litigated in the non-payment proceeding, and then he adhered to this decision in the June 16th, 2025 decision on the motion to re-argue. So we're talking about fees on a non-payment case that was litigated, around 4 or 5 years ago at this point, and this can be distinguished from Parker v. Blauvelt, which is the case that the plaintiff has cited a couple times, because the plaintiff had the opportunity and actually did fully participate in that litigation. She filed multiple orders to show cause and was fully aware that the case was going on. And then just turning to the point about the lower court properly dismissing the plaintiff's third cause of action as being duplicative. So the lower court originally dismissed plaintiff's third cause of action for promissory estoppel based on the documentary evidence contained in the record that she had received a surplus check, a check for the surplus amount from the sale of the apartment, and then adhered to that determination. So a claim for promissory estoppel will be dismissed when the claim is merely duplicative of a claim for breach of contract.
Thank you. We got it.
Thank you very much.
All right. You have 1 minute on rebuttal, ma'am. You have 1 minute on rebuttal.
Number one, on default judgment service, if the defendant received actual notice and fully responded as they admit, how can they claim prejudice under CPLR 2001? Isn't this is just elevating a technicality of a substance? Number two, an implied in fact contract. The notice promised a surplus after a reasonable sale, yet $310,000 price for an $850,000 asset screams unreasonableness. How does the closing statement usually refute a factual dispute on commercial reasonableness? Number three, on RPAPL 702 and res judicata, housing court could not award RPAPL damages. Its jurisdiction is limited. How does res judicata apply when full relief wasn't available there?
Thank you. Your time is up, but we have your briefs. Thank you.
I have two more.
Thank you. We are done. People versus Frederick White. You may proceed.
Thank you, Your Honor. Good afternoon, and may it please the court, Paul Anderson for the people. In a trial where there was crime scene, forensic, and medical and firearms evidence demonstrating that Lovelace was shot twice in the neck while asleep in her bed, the lower court erred in finding that Detective Rodriguez's testimony was material in determining that defendant intentionally shot her in the neck twice while she slept.
So let me just ask you, you're not disputing that there was a Brady violation here, right?
Well, for a Brady violation, there has to be the materiality prong. I'm not disputing that we didn't disclose the lawsuits or the CCRB summary, and that they were
And you don't think that that information would have been useful to the defendant?
It's not that
Well, couldn't it have convinced him not to testify if he was if the officer was well cross-examined? Couldn't he have decided not to testify?
Your Honor, there would still, sorry to interrupt, but there would be no other way for Mr. White to get out that this was an accidental shooting here, in light of all the other evidence, including...
Just as my colleague just said, defense was deprived of the opportunity to decide whether he should take the stand or not, because the witness, the main witness who had the greatest amount of discussion with him and taking the statement, right? The real statement, the sit down in the room statement, right? The non-Mirandized statement, right?
What do you mean by non-Mirandized?
But it's not recorded.
It wasn't
right?
recorded,
It
right?
wasn't recorded.
Unrecorded statement. And he refused to write anything down. So the credibility of this offer was very much at issue in this case.
It was not, Your Honor. I would agree, just like in Garrett in the Court of Appeals, that testimony was undoubtedly important, but it wasn't material here, where we had all the other circumstances.
So the verified complaint for Javier versus City of New York was not material?
Yes, Your Honor.
For impeachment purposes?
It would not have changed, it would not have resulted in a reasonable probability of a different result here.
So
Is that the standard?
that's what I want to know. What are you
It is, Your Honor.
saying
We're
is,
not-
what is the standard? I'm sorry, I didn't mean to interrupt you, Ken.
What is the standard?
That's what I want to know. What are you saying is the standard for material? What do you have to show that it's material?
The standard for materiality is a reasonable probability of a different result, which, put it another way,
Is that still the standard? I don't know.
yes, Your Honor, it is.
There's talk about whether the process was fair,
Yes, Your Honor.
regardless of whether one can say that the outcome might have changed.
Yes, Your
right?
Honor, I think...
So even if I agree with you that there's a lot of evidence here.
Your Honor, I'm not trying to do a balancing of weight of the evidence review here. And I agree, we all look back into the reasonable probability of different result because it ties into whether defendant received a fair trial here, whether there's a due process violation. And it's the same reasonable probability of a different result standard as we have for ineffective assistance of counsel, right?
Wasn't that the ultimate standard under ULIT, that the trial results in a verdict of confidence?
Yes, Your Honor, exactly.
Well, a verdict worthy of
A
confidence.
verdict worthy of confidence. And here we have that because despite what the lower court found below, Detective Rodriguez's testimony relaying the confession, which that confession was also not really congruent with all the other evidence here, and that Mr. White told Detective Rodriguez, and he wanted to tell a different detective, that yes, I shot her in an argument because she was going to call the police. But what we have here showing there was no evidence of an argument. Sasha was in the next room, didn't hear anything. What we have is all the medical, the Dr. Landy testifying, and the photographic evidence of Mrs. Lovelace lying on the side of her bed, the blood bleeding straight down, and testifying in her opinion, she was shot twice in the neck through a pillow while she was lying down. So there was so when defendant took the stand, or even if he didn't take the stand, this was enough, and there was confidence in showing that.
Was there confidence?
Let Judge Kapnick.
Can I ask you a little bit of a different question? So in the summation, the ADA trying the case, didn't she perhaps go on to bolster the testimony presented by Detective Rodriguez when you knew there were some of these problems and they did not know about some of these problems? And doesn't that sort of add to the issues that we're dealing with on the standard of did he get a fair trial?
And she didn't even need to do that because the evidence was overwhelming.
Well, Your Honor, I'll address that. So I think you're touching on people Flores, and I believe you were the justice presiding on that case in terms of enhanced prejudice based on summation. But here, if we read the summation, the prosecutor wasn't saying, and we know this confession is truthful and exactly what happened. No, the prosecutor was responding to defense's arguments that Detective Rodriguez lied on the stand about doing this video interview and saying he never did a video interview. However, let me press the tape. He's actually doing a video interview. But then the prosecutor rehabilitated and said he was asked, did he do a video interview in the 52nd precinct? And no, what he did was on the other side of the Bronx in the 41st precinct. And so, yes.
And what would the attorney have been able to do further had he known about Javier, the verified complaint?
Not much, Your Honor, because the Javier complaint would have just said, the facts of the Javier complaint was that Mr. Javier was coerced into confessing. However, there was no confession from Javier. In fact, then in that case, there was no allegation and there was no evidence that Detective Rodriguez fabricated a confession, which is what the strategy was, or which is what the theory is here. But even at trial, the theory was never, oh, I told him that this was an accident and I don't know why he never wrote it down. It was just sloppy police work and that this wasn't recorded. And then if we look at the other confession, the other lawsuit that was dismissed at the time, Robertson, that was a similar coerced confession, but the plaintiff in Robertson admitted that he told Detective Rodriguez the truth. So when we have and these are also just lawsuits. So if we have all these unsubstantiated, non-final findings that of a collateral matter in which the defense counsel would only be able to say,
I'm sorry.
I can't.
Where part of your evidence for conviction is a confession, the fact that an officer has been charged with coercing confessions is not irrelevant and is not something that can just be brushed aside.
I have two answers for that, Your Honor. One, there was no allegation of coercion. In fact, it was the opposite, and there was no way he could have said he was coerced. He testified that, of course, he wanted to tell everyone. He told everyone about this confession. Two, and I get Your Honor's statement here, but that is exactly the holding of Garrett. Garrett was a coerced confession theory, and there was allegations in those lawsuits that detective who took the confession was beating people with a phone book. And yet the Court of Appeals said, we will reverse the appellate division because they discounted the overwhelming...
What year was that case?
2014.
Okay.
So let me ask
Got
you,
a different court now.
can
I
I,
understand, Your Honor.
Okay,
but we're still looking at the
I'm just
standard here.
saying.
And then
right?
again, also we have the existence of the other detective in the room that they didn't. So if their burden to show that this was,
So frankly, the people should have called that other detective and we wouldn't be here, right?
at
So
trial,
this is part of the problem. This is part of the problem. But you'll have time on rebuttal.
yes, Your Honor.
Good afternoon, and may it please the court, Alexandra Mitter on behalf of Respondent Frederick White.
Counsel, can you please pick up? Your friend says it was sloppy police work, but this wasn't material.
Yeah, I think my opponent here is really missing the forest for the trees. It's not whether the misconduct alleged against the detective here, and I want to be clear, we are not talking about run-of-the-mill misconduct. This is a detective who broke a child's jaw, testified falsely in family court, testified falsely in the ensuing CCRB allegation, coerced confessions, manipulated confessions, wouldn't Mirandize people, ignored exculpatory leads, denied requests for counsel. The idea that none of this would have impacted the way that the jurors viewed the most important piece of evidence
well,
in this
that's
case.
the question. Is it really the most important piece of evidence? The defendant immediately confesses right afterwards to anybody who will listen to him. So I have a hard time believing that that officer's testimony is the linchpin of the case.
So,
and he gets up himself and testifies that it was accidental. So I don't know how you could say that being able to cross-examine that, I agree. I think for myself, I agree that information should have been available to the defendant. But the question is, would the result have been different? And I can't, given that this defendant himself, before he spoke to anybody in law enforcement, confessed up and down to this incident. I don't know how you could say that.
So I think there's a couple points in response, Your Honor. First, the question is not, contrary to the framing over here, whether the result would have been different. In fact, the Supreme Court
Well,
made
I'm reading it.
quite clear.
The question is, the result would have been different. Garrett, 23 New York 3rd at 891. In determining materiality, right, whether in its absence he received a fair trial. That's it, right? So those two things together.
I think with respect to the Court
That's
of
why
Appeals
I'm
in
asking what the standard is.
yes, and I think the Supreme Court in Kiles versus Whitley articulated it clearly. And with respect to the Court of Appeals in Garrett, Kiles versus Whitley is the decision that really controls as a Supreme Court decision. They said the question is not whether the defendant would have more likely than not received a different verdict with the evidence, but whether in its absence he received a fair trial. This denied him a fair trial.
I'm sorry, so
without question.
In Hewlett, didn't the court follow up with that and say, understood as a trial resulting in a verdict worthy of confidence?
Yes,
Is
that's
that synonymous with harmless error? I'm not sure what, where, because obviously there's a difference between a verdict we believe would have been the same and whether the defendant received a fair trial.
Yes, I mean, I think, so that quote from Hewlett also comes from Kiles versus Whitley. So I think it's all of a piece with the concern about fairness. This is a due process claim. This is not harmless error based on an evidentiary ruling. This is a due process claim. And the issue here, to go back to your original question about the sort of impact of the confession, confessions are the most powerful evidence that comes in at trial. Everything that Mr. White said prior to that confession in front of Detective Rodriguez was through tears, I did something bad, I can't take it back. And all of that was true. He did do something bad, he couldn't take it back, and he has regretted it every day since, which is why he testified at trial.
But it's not just that, it's the forensic evidence, right, that showed that there's no way the crime could have happened. It's not just his confession, right?
Sure. I mean,
it's all the other evidence. This was overwhelming evidence. He didn't put in except for his own testimony.
So I think that, first of all, while there is certainly forensic evidence here, and I'm not saying that there wasn't, the experts were quite clear that they could not say that the forensic evidence disproved Mr. White's testimony. And all the arguments that appellant is making here, those are fine arguments to be making to the jury. But ultimately, what we have to focus on here is the fact that a really critical piece of evidence, a piece of evidence that social science tells us is more important than eyewitness testimony, confessions, the only evidence of the intentional aspect of the murder, which is the really only question here because Mr. White confessed to a reckless homicide. The only question here is whether the jury was able to fairly evaluate that really, really important evidence without the context of the person who generated that evidence. And I mean, defense counsel did the best he could with what he had to challenge that confession, which had sort of problems on its face, right? It wasn't signed. There was no signature or initials on the Miranda card. There was no interview start or end time.
What about the testimony that he said to his sister, I believe it was, prior to the date of this, if anything ever happens to Lovelace, will you take care of the kid?
Yeah, so I think...
What about that? So he was thinking about that and, a few days before?
I don't know that it was a few days before, Your Honor, and hindsight is 20/20. I mean, put in a different context, that's just sort of good planning on that's like making a will, right? So I think it becomes somewhat ominous when you sort of look back on it, but I don't think there was any evidence really linking them in the way we would need to link them here. And ultimately, a jury's sitting there wondering, why are we having this trial at all if this man already confessed to an intentional murder? What are we doing here? He's just sitting on the stand trying to backtrack now. The jury was entitled to...
May I ask you, what do you think is difference between what he said to everybody else before he said the statement, which is, I did something bad, I killed her, I did something bad, I killed her, and what he said to the police officer? What was the qualitative difference?
The qualitative difference is that what he said to Detective Rodriguez, allegedly describing an intentional murder in cold blood and demonstrating how he held the gun.
Oh, it was just more, you're saying because it was more detailed.
Not
he admitted he killed her.
So not only that it was, I think it goes to the only question in the case at trial, which was the level of intent here. Mr. White was not disclaiming responsibility. He got up on the stand and effectively contested second-degree manslaughter.
I'm sorry, I didn't mean to interrupt you.
please.
What about the statement he made to the detective at the precinct, I think the Detective Dietrich? He got in there and he hysterically said, I couldn't take it no more, I had to do it, I shot her.
Yeah, I mean, I think, again, this is through tears. He's sort of brought himself in with his hands crossed and take me in, take me in. I think this is a man incredibly distraught, which is a very different picture than sort of the cold interrogation room where this intentional murder confession is allegedly happening. So if there are no further questions, we would ask that you affirm and allow the state to attempt to try to prove Mr. White's guilt again with the full picture in front of the jury.
Thank you. Counsel, you have 2 minutes.
Yes, Your Honor. As Justice Kapnick just pointed out, yes, we have that confession or that statement to Dietrich of, I had to do it. That doesn't negate intent. That excuses it. And we have also his entire, the itinerary between his shooting, calling 911, not staying, not rendering aid, not explaining what happened, and then later denying that that was him on the call, then going all across the Bronx, going to Edenwald to drop off the older daughter, going to his sister so distraught at learning that he's confessed to her and her mother that he's killed her, that she calls 911 in tears saying, he just told me he killed her.
Are you saying, I'm sorry to interrupt you, but I want to just ask this, are you saying that the confession was not materially different from all the other confessions he made prior to telling the police officer?
Correct, Your Honor. And not only that, that confession to Rodriguez, we weren't latching on and saying, jury, we want you to credit that confession, because that confession was, again, a sanitized version of what he actually did. He didn't shoot her during an argument. He shot her while she was asleep, threw a pillow twice in the neck in rapid succession, and there's no way that is an accidental shooting. Plus, we have the evidence of them decoupling, his prior abuse, the evidence from Sasha saying there's absolutely no argument that happened ahead of time. So there's no way that this happened at
So then how do we prevent this from happening? How do we, I mean, this, what are you suggesting? That that was okay? That this cross-examination testimony, which probably would have eviscerated that police officer, we should just ignore that?
Your Honor, what we look at for reviewing Brady claims and due process violations isn't really punishing the prosecutor, and I agree. This should have been turned over. Defense should have had that. I think going forward, 245, it has made it better for us managing that information of when we get sued by another person, that goes in and gets redistributed properly. I can't contest that, and I shouldn't, because that should have been turned over. But going forward, this isn't a deterrent effect here. The determination.
That's not the issue is whether this defendant got a fair trial.
Yes, Your Honor.
That is the issue.
That's the issue. I agree, and I don't disagree with the standard that Justice Higgett and my colleague mentioned in terms of a reasonable probability of different result, which also includes whether the jury's verdict, you can have confidence in the jury's verdict, and giving all of the evidence here, including defendant's own testimony, all of that evidence.
And do you think, counsel, because I did criminal myself, right? A 30-minute verdict on a homicide, right? I just can't see in any universe how that would have happened had the defense had the ammunition they would have had to cross-examine. That jury would have been given a lot more to think about, and I don't think you would have gotten a 30-minute verdict.
I think, well, we have the testimony of the defense counsel who says who looked at the jury's reaction in response to defendant's testimony, and that's what they took away with them, and that's why they had confidence in being like, there really isn't an issue here. Whatever he said to
And the cross-examination of the officer would have happened before
Yes, Your
the
Honor.
defendant took the stand, right?
Yes, Your
So
Honor.
if the defense had been able to eviscerate the key witness,
Yes.
perhaps the defendant would not have taken the stand, but we will never know that. I thank you.
Eviscerating the
I
witness is
thank
not an
you.
understatement. Thank you, Your Honor. I ask that you reverse.
Gilbert versus Sandra Powers. Justice Kapnick is recused from this case. If there should be a tie, we will follow appellate division rules and vouch another judge in. Okay?
May it please the court, my name is William Dunnigan, and I represent the derivative plaintiffs, the appellants. We have here a pure question of law concerning the collateral source rule. I'd like to make 4 points. 1, the whole purpose of the collateral source rule is that a plaintiff may be able to recover for a loss that the plaintiff has not sustained. Now, that's because the existence of insurance creates a windfall. The question is, who gets the benefit of that windfall? The rule of law in New York should be that the party that pays for the insurance gets the benefit of the insurance. Point 2, The 2009 amendment to CPLR 4545 affirmed that the common law collateral source rule was alive and well, except in cases involving personal
Wait,
injury.
let me ask you something. Everybody paid for the insurance, right? The plaintiffs and the defendants.
Well, it's a condominium of
Right, so either none of the plaintiffs, none of the individual plaintiffs paid for it, or all of the plaintiffs and defendants paid for it, or the condiment, you have individual claims, right? Not just derivative claims. So that only, you're saying, if you're saying that, that would not inure to the individual plaintiffs, only to the condominium.
Well, we are suing on behalf of the condominium.
Well, you're suing individually
Yes,
on behalf.
for very limited rights, and those are not involved in the claim that we asserted for the 4.5 million. I mean, we are asserting the condominium's claim because the condominium paid the money.
Right,
under
and
the settlement.
defendants would be all equally, right, responsible for paying for that money, right?
Well, I'm not.
All the condo members pay for it, not just the plaintiff condo members.
Well, everybody paid a common charge in a percentage that goes toward the insurance indirectly. Now, the point they're trying to make is that, wow, we paid for 1%, therefore we get the benefit of the whole thing. That shouldn't work, because if they paid for 1%, then they get a 1% benefit from the judgment that we obtain on behalf of the condominium in this case.
The claims that you are asserting are against the individual board members for breach of fiduciary duty, which is different from what was settled.
What was settled were the claims of Park 56 against the condominium association.
So that insurance payment didn't go to pay your individual claims of the breach of fiduciary duty. It was the board claim, right?
It was the condominium association's
Yeah,
claim
not yours,
against
not
the
yours. It was condo board against condominium, right? I'm sorry, it was against the
One unit-
sponsors.
It was one unit owner against the condominium
Right.
association represented by the board.
So those damages don't inure to you.
No, we're not trying to recover damages.
Yes,
for
that's
ourselves.
exactly what you're saying. The 4.5 million is ours, should be ours,
No,
right?
it's the condominiums. We are suing on behalf of the condominium. We aren't pocketing, my derivative plaintiffs aren't pocketing anything.
How much did the condominium pay itself?
Itself, $1 million out of its own pocket. Insurance paid 3.5. We're saying under the collateral source rule, they should get the benefit of the 3.5.
And what are the damages that are recoverable on a claim for breach of fiduciary duty between a board and or between unit owners and the board members?
Well, here, because there's a bad faith breach of fiduciary duty, that's our allegation, the damages are not just the settlement payment, but there are additional legal fees that were paid by the condominium and not reimbursed.
No, what are damages on breach? It doesn't matter who they are. It doesn't matter if it's breach of fiduciary duty automatically means bad faith. What are damages in breach of fiduciary duty causes of action?
The damages are what proximate.
Out-of-pocket costs, right, and lost economic damages. It's pretty straightforward. I was trying to get you to say it, but I'll say it for you, right?
Okay, it's economic loss.
So that's, what is the economic loss that that the board suffered?
The condominium association suffered if we go to trial, we prove that there was a $4.5 million payment made to.
You didn't make that payment, so you didn't suffer that
See,
loss.
that's the point of the collateral source rule. It's not admissible in evidence.
Okay.
That's the whole point. I mean, what Your
All right.
Honor is saying is.
You'll have time on rebuttal.
Thank you.
Yeah, because we're not having this. You may proceed.
Thank you. Good afternoon. May it please the court. Ari Silverman on behalf of respondents. There's no debate that when legislative intent is known, the courts are duty-bound to follow it. The Court of Appeals said that. The Court of Appeals also said that there's no clearer expression of legislative intent other than the legislative annual that comes out every year. And in 2009, the legislative annual stated that CPLR 4545 was enacted to eliminate the collateral source rule. There's no interpretation needed to understand eliminate.
More fundamentally, the collateral source rule isn't a cause of action, right? The collateral source rule, well, the statutory one, is an offset. So I'm not sure that collateral source is even implicated here. They're raising a certain cognizable cause of action. And now the question is, you would raise the common law collateral source rule as, I guess, a shield to the liability, right? Because it's not the common law collateral source rule was not a cause of action. It was just a rule that didn't bar recovery of an otherwise cognizable claim.
That's correct, but the appellant's argument is that the common law collateral source rule here serves to make the payments available to them because it's a fiduciary duty claim.
So how would that connect to what their damages are? What are the, I mean,
Well, that was the trial court's point.
Right.
And that's why this court can affirm the trial court without even passing on the collateral source rule. The condominium was not damaged. It didn't pay any money.
well, it may get attorney's fees, right? That's an out-of-pocket.
Correct.
And I don't know, maybe the condominium's going to prove that its insurance went up $1 billion after having to pay this, like
Well,
car insurance, right? Those two would be out-of-pocket losses.
And that's what the trial court found also, and we're not here to debate that. We're here solely on this motion for partial summary judgment, where they're seeking the $4.5 million payment that was not the condominium's damage. There's nothing to recover there. So that you can affirm the trial court's decision without even passing on the collateral.
I just want to ask you, was the summary judgment decision was also appealed, correct?
Correct.
And was before me, I think, a couple of weeks ago.
That's correct.
Okay,
1
all
month
right.
ago. Two summary judgment motions and a discovery motion.
Right. Okay. So this doesn't, right. First we have to figure out that motion, that appeal, and then this appeal, right?
Agree. The outcome of that appeal may moot this entire discussion.
Or not.
Correct. May, if liability is found to be appropriately assessed against the defendants. I have nothing more to add.
Thank you.
Your Honor, I want to go back and address your point that you don't have any loss in the event that the insurance company pays. I'd like you to take a close look at Section 4545 in cases that do not involve personal injury, property damage, or wrongful death. In those situations, the plaintiff is going to be able to recover amounts even though the plaintiff has not sustained that loss. That is the rule of 4545, which was enacted in 2009. So
I thought you weren't, are you arguing that the statute applies?
I'm sorry, Your Honor.
You're arguing that the statute applies or the common law applies?
The common law applies.
So then those cases under the statute are irrelevant.
Well, the cases under the statute define what is personal injury, wrongful death, injury to property. This case is not one of those. The common law applies, but if you're trying to figure out whether or not the collateral source rule still exists in New York State.
No, I'm trying to figure out whether it applies to a breach of fiduciary claim, which has a pretty straightforward set of damages.
Yes, that's a different question, Your Honor.
That's what I've been asking you. It's exactly why I asked you, what are the damages recoverable?
We prove the amount that was paid to Park 56. They cannot offer any evidence that Park 56 was paid by insurance because the collateral source rule under the Odin decision is both substantive and evidentiary. Thank you.
Thank you. Alvisurus versus North State Realty. Let's wait for my colleague. Of course. You may proceed.
Good afternoon, Your Honors. May it please the court. Travis Wong for the plaintiff respondent. I just want to address some of the arguments made in reply. Defendants try to paint this as a hazard that was only there for 45 minutes or something that just occurred recently, such as like general awareness of a tracking in liquid.
Is there any dispute that it was snowing and 18 inches fell during that period of time?
No, and this is a storm.
Oh, it was a storm in progress.
It was a storm in progress, and this is a storm in progress analysis that for something that occurs indoors. And there's a specific analysis for that set forth by this department, which requires that defendants take reasonable measures to prevent slipping hazards. And here, plaintiff testified that there were no mats, and that there were no warning signs, and defendant's own witness testified that they had a standard to do so, and they didn't present any evidence that those actions were actually taken. So therefore, we believe there's a question of fact, and defendant's motion was properly denied. If the court has no further questions, I'll rest on my brief.
Thank you.
Thank you.
Serrano versus Judla Contracting. You may proceed.
Good afternoon, Your Honors. May it please the court. My name is Joseph Santiago. I represent the appellants in this case. The appellant should have been granted summary judgment by the lower court. As you know, plaintiff alleges that he tripped and fell over an unramped corner of a metal road plate that was being used for water main work. The appellants produced a photograph. It's in the record, page 308. The photograph shows that on the day of the accident, which this was authenticated by the defendant's project manager, this photograph was taken on the day of the accident. It shows that there are 4 to 5 large orange construction barrels. They weigh 10 to 15 pounds each. They were blocking this corner of the plate where plaintiff says that he fell.
That photograph was at 1:17 in the afternoon, and the accident happened at 6 p.m., so it's frankly not enlightening on what was occurring at the time of the accident.
The photograph was taken at 1:17 in the afternoon per the metadata, Your Honor, that is correct. However, Judla's project manager testified that this was the state of the site at the time all the employees left the
No
site, which
one
was
said that.
4:30 p.m.
No one said that.
The Judla...
No one said that they personally saw that. No one. I checked this record.
The Judla project manager said that the barrels are always left here at the end of each.
What is always done is not evidence of what was done today. So, and we have plenty of case law that says that.
Okay, well, even even accepting that, Your Honor, plaintiff testified initially that the barrels were in this location where he fell. When he was initially asked to describe the incident as it occurred, he was asked if there were orange barrels in the area on page 101 of the record. He said yes.
Well, they were in the area, but I thought that there was conflicting testimony as to whether they were moved at the end of the day. I think the accident happened at 6 o'clock. So there seems to be an implication that they may have been made. Now, look, plaintiff didn't move for summary judgment. You did, so you have the obligation to prove everything here if you want to, win on the papers. That's the problem.
Understood, Your Honor.
One of the problems, at least.
And plaintiff initially testified that he fell about half a foot away from the fence, and there were barrels about a foot to his right, which is in line with the photograph, which is the best known evidence from that date of the accident.
But didn't he also testify at deposition and in an affirmation that the barrels were not there at the time of his accident?
He later testifies, about 30, 40 pages later, that the barrels were not as close as depicted in this photograph.
And
then
the
he says-
project, sorry to interrupt you, and the project manager says she doesn't know if they were moved after that picture was taken at 1:17. She just knows that they would have been put back.
Right, so she knows.
Generally speaking.
She knows-
That's not sufficient evidence under our case law, is the problem.
And she knows, Your Honors, that the barrels would be left there at the end of every day. She did not know whether the barrels were moved. Plaintiff in his affirmation submitted in response to summary judgment, having never done an errata sheet, says the court should ignore all the testimony that is detrimental to plaintiff and just accept the fact that he is now saying later on in the record, in the testimony, that the barrels were not as close, and then later says in his affirmation the barrels weren't there at all. And that shouldn't have been accepted by the
Counsel,
court.
everything that you have described doesn't sound like summary judgment worthy, right? There sounds like issues of fact, even as you are describing the record.
I can understand what you're saying, Your Honor, but the court can discern between issues of fact and feigned issues of fact, which would be insufficient.
Oh, so we should now inject credibility determinations into summary judgment motions.
It's not quite credibility, because obviously
It
that's
kind of
correct.
is.
Well, that is correct, Your Honor, that on summary judgment, credibility issues would not be appropriate. But when there's a feigned issue of fact raised by an affirmation that improperly changes the testimony, that should be discounted by the court.
Okay.
And just as to one more point, the issue of the storm in progress, even accepting that maybe perhaps the barrels had been moved between the close of work that day and plaintiff's accident 2 hours later, as Your Honor pointed out, the Judla project manager had no notice of the barrels being moved due to the ongoing snowstorm in progress. Sorry, Your Honor.
May I ask you, didn't, I mean, there were discrepancies in the plaintiff's testimony, right, which we would normally say raises an issue of fact, but didn't he explain them by saying that he has hearing impairment and there was a difficulty with him reading the real-time transcript?
So
couldn't we accept that explanation without making an evidentiary finding and as to that not being a discrepancy but an explainable difference between his testimony?
I'll respond to that point briefly since my time is running out. But
Fine now. You may not remember what she asked you, so go ahead.
Plaintiff was asked whether he was able and comfortable to proceed with the closed captioning and the technology as it was. On page 82 of the record, he said it's no problem, he'll proceed.
I think people say that all the time. They don't want to be a bother.
Sure.
Right?
And he was
no one wants to be a bother until they realize it's a problem.
I understand that, Your Honor. He was served with a deposition transcript. This happened in 2021, the deposition.
Right.
He did not provide an errata sheet. He has never pointed out specifically what testimony he would like to correct.
Said this already. Thank you.
Thank you, Your
Have
Honor.
a seat and you'll have time on rebuttal.
Thank you.
Counsel?
May it please the court. My name is Stephen Pecoraro from the firm of Pecoraro and Chisel, and I represent the respondent. It's the appellant that has the burden of proof here. It was the appellant that moved for summary judgment in the underlying court. Aside from their witness's transcript that was submitted as an exhibit being not signed, and again, I'm not talking about their adversaries, my client's transcript being unsigned. This is their own transcript being unsigned. Aside from that defect, the defense is relying on these photos, but in the underlying record, and in the record here before the court, the photos that were referred to in the defendant's moving papers in the underlying court, the ones with the deposition exhibit tabs weren't even part of the record. And they're not part of the record here before this court as a result. So with respect to the defendant's witness, if you take a look at the record, page 282, it's the exhibit index, and two photos were marked as exhibits numbers 1 and 2, and there are no exhibits marked 1 and 2 in the record. So the photo that defense counsel just showed you, if we take his word for it, maybe that's the exhibit, but we need to rely on the record, and that's not in the record. Similarly, with respect to the photos marked at the plaintiff's deposition, the marked photos are not part of the record either.
So I looked at a bunch of photos that were in the record. Were any of those marked? Did the plaintiff mark any of those photos as to where he says exactly he was when he fell?
The only photos that are identified in the record with some type of marking or other identification are those that were attached to the notice of claim form. And those were the notice of claim form with the 3 or 4 photos were defendant's exhibit B in the underlying record, and they are in the record starting at record number 32. Three or four photos, and also again around record number 301. And those are the photos. Again, they were attached to the notice of claim. They're referred to specifically in the plaintiff's affidavit or affirmation, if you want to call it, but it was sworn to. It was signed by notary. He referred to those as showing the defect, and there's clearly an unramped corner of the plate. So aside from the defendant's witness's transcript not being signed, and they being the moving party in this case, none of the photos that they're referring to were properly put into the record. The only photos properly in the record are the ones that the plaintiff referred to and identified as showing the defect.
So you're saying it's kind of tough for him to win on summary judgment. An issue of fact, see what happens at trial, but...
Absolutely. To button up all the holes, to oppose their summary judgment motion, I produced an affidavit from my client. The defense could have and probably undoubtedly should have produced an affidavit from whoever was on the job site who was there till the end of the day. Their witness in her deposition testified that 75% of her daily workday was spent in the office. And I quoted that in my papers.
Thank you.
Thank you.
Just briefly, Your Honors, as to the couple of points here. The defendants properly relied on Ms. Ippolito's testimony. Although it was unsigned, we could submit it, and when it's used as an exhibit, our own client's testimony, we adopt that testimony as accurate. As far as the photograph that we were discussing before, that was the record page 308 photograph. That was shown to plaintiff at his deposition, and he also agreed that that depicted the area of the accident. So it was properly before the court in the record. And then we had gone on over this. I don't want to repeat myself verbatim, but Ms. Ippolito testified that this is the photograph from the day of the accident. It depicts where the barrels were left at the end of the day. The plaintiff took this odd route around the lamp, around the garbage cans. Instead of crossing through the crosswalk, of which he testified there's nothing preventing this, he crossed all the way in this corner through these barrels next to the fence. And as far as the storm and progress doctrine, plaintiff did not address this in opposition. It's something that should have been deemed admitted by the court. And if no further questions, I'll rest on my papers.
Thank you, sir.
Thank you.
B. Andrew versus Algra. May proceed.
Good afternoon, Your Honors. May it please the court. Jed Schlachter on behalf of the appellant Algra. There are primarily two issues in this case. First issue is, did the family court have jurisdiction over this particular matter? Second issue is, was the 8-second crude outburst by my client harassment in the second degree? On the first issue, I respectfully submit there was no jurisdiction with the family court, because what you have here is a couple that had been a couple until October of 2021. They had split up. This event that's at issue occurred in May of 2024. And what happened was, in all that time after they split up, no more intimate relationship, no relationship at all other than property, over a piece of property. Now, that property was a dog, but it's still property. And the only connection they had was to exchange on a very limited basis that piece of property.
So doesn't their prior intimate relationship going as far as registering as domestic partners give us jurisdiction?
No, I think you...
What jurisdiction?
No, the qualifying relationship should be at the time of the petition.
That's not what the law says.
What the second department does say that in the author suggests that you have to have the qualifying relationship at the time. The YM decision in the Family Court in Kings also suggests...
The Family Court Act, Section 812.1 says that family court has limited concurrent subject matter jurisdiction with the criminal court concerning acts which constitute, among other things, harassment in the second degree when the complained of acts occurred between persons who are not related by
consanguinity.
Yes, thank you. Or affinity, and who are or have been in time.
Yes.
Have been in an intimate relationship regardless of whether such persons have lived together at any time.
Yes, it does say that, but it's also in that same provision, farther down, it talks about, in any proceeding pursuant to this article, a court shall not deny an order of protection or dismiss a petition solely on the basis that the acts or events alleged are not relatively contemporaneous with the date of the petition. So
Counsel, let's
that's
say we
all-
don't agree with you. Can you talk to me about the 8 minutes when she was
Yes.
devastated over her Georgia peach?
Thank you. Yes. First of all, the meeting or discussion lasted for approximately an hour, of which 35 minutes was tape recorded surreptitiously. As your honors can see by reading the transcript or hearing the tapes, she was getting more and more distraught.
He doesn't have the dog. He's supposed to bring the dog, and he doesn't have the dog. And
Correct.
He
And if he's so concerned about his safety, he stayed for an extra 25 minutes to try to calm things down after she made that statement. Am I correct?
He stayed there for another 20 minutes. He went into the hall with the boyfriend. And then the next 2 days, she and the boyfriend sent emails to him saying, please, are you going to return the dog? And what happens 2 days
Goes to
later, on the 24th, she
goes to
files a
family.
police report. So if she intended to do anything harmful, why is she filing a police report? And what's significant, with all due respect to the lower court in her decision did not take into account the police report. You know, lower court said what she looked at. And that police report is very, very important to this case because it shows under the circumstances, there was absolutely no intent here. And it was
My
an
colleague has a
I
question.
just want to clarify, and he didn't bring the dog, but he brought an agreement that says you have to give me the dog, you don't get the dog ever again, and then I'll pay you the money I owe you back?
Yes.
So she never thought she would see her dog again.
Correct.
All right.
Correct.
Okay.
We got it. Thank you.
Thank you, Your Honors.
All right. AEB Fund versus Duval and Stachenfeld. Please wait for my colleague to get back.
Is he okay?
Huh? Oh, yeah.
Let me go check on him.
There he goes. You may proceed.
Good afternoon, Your Honor. Sean Schatzel of Lewis Brisbois, appearing on behalf of the appellants in this legal malpractice action. May it please the court. Your Honors, while this appeal focuses in part on our contention that the trial court should have vacated the note of issue, the real meat and potatoes, the reason I'm standing before you here today is the privilege issue. We believe that the note of issue should have been vacated regardless of the privilege issue, but the focus here is...
Why should they be punished when when the court requested of you a privilege log, you didn't provide it, right? You haven't provided, the judge didn't ask you for a privilege log? You declare documents are privileged, that's it?
I'm the defendants, Your Honor. The plaintiffs were asserting the privilege, and they did provide a privilege log.
Okay.
This is part of our argument against them, that they were delayed with their discovery responses. So I guess before I get to the merits of the privilege
And
issue,
you guys weren't?
no.
No.
No. I could walk you through that, Your Honor. So that was the basis.
That would be a first
Well-
in the history of all cases in these courts that the defendants are not delaying. That would be a first. But go ahead. I'm going to give you
So-
time to prove that.
Fair enough, Your Honor. So that was essentially the basis for the trial court's order, right? They didn't get to the merits of the privilege dispute. They said you were belated, you unexcused delays, all that. So let me walk it through. Our initial demands, which requested the information on issue, were in October 2024 per court deadlines. Plaintiff didn't timely respond. We issued a good faith letter in January 2025. A month later, this is all on the record, plaintiff served some, but not all, of the plaintiff's responses. And at that time, the plaintiff asserted privilege over some of the items. In May 2025, this is now 7 months after our initial demands, the plaintiffs finally served what they view as their complete production. And that was the first time they disclosed witness information, 7 months after our demands. And that same month, which was the month that we finally received what the plaintiffs claim is their full responses, that same month, we served written objections saying, we believe you've waived the privilege, you have to give us this discovery.
Isn't part of the problem here that it seems like you actually at some point filed a joint letter, didn't you, requesting a discovery conference and extension of time to file the note of issue. And somehow, it seems like the court never got to the merits of this. It was just saying, oh, you didn't do this, you should do this, time, but nobody ever dealt with the
That is our concern,
privilege
Your Honor.
issue, right?
Yes, that is exactly our issue. So what we did, we had a meet and confer process with plaintiff's counsel.
Right.
That was initially pushed off a little bit because counsel was not yet ready to discuss it. We finally had that meet and confer. We resolved a bunch of issues amongst ourselves, but not the privilege dispute. So then, as Your Honor said, we send a joint letter saying we have this dispute, and the way the court's rules read was you have to send that letter before the court will authorize you to file a motion. We contacted the court. We said, what's going on here? And the court said, we'll address it at the July 10th compliance conference. And our whole issue is it wasn't addressed.
It wasn't addressed.
We met with the law clerk. We met with the law clerk who
Right,
basically...
and the law clerk says, file a letter, and you don't file a letter.
Well, let me address that. The law clerk says, send an email outlining the dispute.
Right.
By the way, we had already sent the letter outlining the dispute,
Right,
but they say
so-
send an email,
yeah.
right? Yet, that same day, the judge signs that compliance conference order. So July 10th is the date of the conference, okay? And the judge signs the compliance
Right,
conference
but it's okay, but that wasn't entered until July 17th, a week
July
later.
7th.
So, 17th.
I'm sorry, I mean
July
7-day delay.
17th,
You're right, Your Honor, yes.
So the judge signs it because there's 10,000 things going on, holds it, hoping that you're going to submit the email that the court asked you to submit to sharpen up that issue, and you don't do it. So then 7 days later, when you haven't done it, the court says, guess I didn't hear from you, guess it resolved, signing the order, entering the order, and you have until August 10th, right?
Your Honor, I would say, one, the fact that the court signed the order on that date, I think is the real dispositive point. Okay,
It's
but even
not,
if-
because I can sign it, until it's entered, it means nothing. And it was entered 7 days later.
Even if Your Honor disagrees with me on that point, the compliance conference order doesn't address the privilege issue, right? It doesn't discuss
Right,
privilege.
because the court said
That's
to
why you should have sent the letter.
Your Honor,
You didn't send that, you didn't send that email or that letter, right? Let's agree that between the date of the conference and the date that the compliance order was entered, which was 7 days later, up against a month later note of issue date, you didn't do anything, did you?
in the 7-day period Your Honor is talking about, you are correct that the email was not sent, okay? But again, we had sent a letter before then, which outlined the entire dispute and our entire argument, right? So the court already
I
had
know,
that.
but you see, listen to what you're saying.
Yeah.
You get a direction from the court attorney who says, send my judge a letter. Who knows the judge better, you or the court attorney?
Of course, Your Honor.
So follow the court attorney's suggestion, right? You don't do that. And now we're here, okay? You'll have time on rebuttal because you have the red light.
Good afternoon. May it please the court. Andrew Bluestone for plaintiff, respondent.
And you're part of the problem because you don't turn over the privilege log.
I did turn over the privilege log.
Immediately?
As soon as we had it, yes.
Well, that's a funny answer.
We resolved all of that. We had over 150,000 pages going back and forth, Judge. There was a tremendous amount of discovery going on, and I had to review every one of those.
Wait, I'm unclear. You said you turned over the privilege log as to successor counsel's documents?
Of course.
So what are we here for then?
God knows.
Okay.
No, but really, their motion is kill the note of issue, right? That the judge abused her discretion, that she can't manage her own calendar, she can't decide what.
No. Their argument is that you waived the privilege. You put out you gave them a bunch of documents.
Yes, I did give them.
And that should have been addressed by the court. That's not an illegitimate argument to make.
No.
Because if it's true, then you have a lot more documents to turn over.
Well, it's true that I inadvertently gave them.
Well, I don't know whether it's inadvertent.
But I mean, to the extent that you claim that it's inadvertent, and I saw that, how come you didn't make any efforts to immediately claw it back or something to indicate that, oh, we didn't mean to give it to you?
Well, we told them that was inadvertent. We didn't make any attempt to claw them back because they were vanilla discussion. They were communication.
Well, that's what
you
you
understand
say.
the import of it. You understand that if you let out some, that opens up the whole Pandora's box. So you have to do something and notify everyone, oops, I made a mistake. I'm not,
Waiving the privilege.
yeah.
We did notify defendants. We didn't make a motion. That's true. We didn't make a motion because there were just a couple, and we were trying to get the rest of the discovery done.
Counsel, your client is suing someone for legal malpractice.
Yes. Well, okay, so let me go into what the privilege then. Okay. The legal malpractice in this case was the failure to file the notice of claim.
Right.
Okay, and that happened in May
In
of.
the bankruptcy action, right.
Subsequent counsel were hired afterwards to try and fix the problem. They have there's no sword, there's no shield, there's no necessity.
But isn't that is precisely why they want the discovery, because they want to make sure that subsequent counsel did everything they could to mitigate whatever mistake.
Well, they have the motion.
Okay, so.
They have the motion, and they have the appeal. Subsequent counsel made a motion, lost it on Pioneer. US
No, but I thought that I thought that part of their claim was that they need these discussions with successor counsel to deal with their defense that, well, it wasn't all our fault, it was also the fault of successor counsel. Now, it may or may not be, but they're saying we need those documents. You're saying those are all privileged. They're saying you may have waived the privilege. Doesn't that have to get worked out?
It actually doesn't, and I'll explain why. The discussion on how to fix the problem, which was unfixable under Pioneer, the US Supreme Court case, because it was law office failure, law office negligence in not filing it does not inure to the benefit of the plaintiffs under any circumstances, according to the Supreme Court of the United States. Anything they did afterwards was on papers. It was a motion that they made. It was an appeal that they took. Whether they did a good job on the motion or the appeal is apparent on its face.
But
And
there
they
are
can argue that.
documents, there's a document that suggests, and I don't know if it's true, that they didn't put in certain things or they didn't make any certain arguments so that they could preserve their malpractice claim. That goes to whether or not that the plaintiffs mitigated damages.
And it's on the face of the papers.
On the
whether
documents that
No,
that
it's on
were,
the face
that
of
were
the motion made to the bankruptcy court. It's on the face of the appeal.
That's for the court to decide whether on the face of the motion that is enough for them to be able to defend themselves.
And the court did decide that there was no
Okay, and we are here to determine whether that's right or wrong.
Yes, Your Honor.
No, I think the court didn't. The court said, I'm not going to deal with it because they didn't raise it timely, and now the note of issue is, the court didn't resolve this issue at all. That's the problem.
In a default setting, they did.
Well,
By saying, you know.
Well, there's nothing
waited that
arbitrary,
everybody-
capricious, contrary to law here. And this is
as to what?
As to either the note of issue, the discovery schedule, or the privilege. Those are all discretion arguments, are they not?
But if the judge made a decision on the privilege, I didn't see that the judge made a decision on the privilege. I think that's part of the problem.
Well, she denied their ability to get the stuff on papers, and that's part of the.
Where does she deny their ability to get
In the compliance conference, she said there's no.
She said, there's no outstanding discovery, but it seems that there was, and she had received.
Showing the privilege is implicated here. That's what she says.
Well, I'm going to look at that.
It's in my brief.
All right, thank you. Counsel, you have time.
Let me try to get through a few items.
Did the judge say that there was no indication that there was, I didn't see that.
Not in the compliance conference order and not in the order on appeal. Briefly, on the 7-day email delay, okay, I would just note that the court's decision on appeal did not rely upon that. They didn't say, oh, you didn't send us that email, so you're not getting it. So that wasn't raised by the court. If you read plaintiff's brief, they don't raise that argument either. So I do not believe this appeal should be cited on that issue. Okay, counsel said the mistake that we allegedly made, and we say, by the way, that this wasn't in the scope of our representation. That's not before you on this appeal, so I don't need to get to it. But they say it was an unfixable problem, insurmountable, impossible task. I cite in the brief Cheney, Sixth Circuit, which was a good faith miscommunication between lawyers that the court deemed a good reason, a valid reason for the delay, okay? And that was cited favorably by the Fourth Circuit, which controls here because we're North Carolina, in Gant, okay? And our argument is the record here could support an argument that there was a good faith miscommunication between the plaintiff's principals and our client, okay? And if they had raised that argument, which is supported by the record, they would have had a very good chance of succeeding. They failed to do so. Finally, Your Honors touched upon it. When you disclose certain items, you're disclosing, you're waiving the privilege as to everything having to do with the subject matter. That's Arkin, Kaplan, Rice cited in our brief. That's also the Cirrus partners cited in our brief, okay? By disclosing those emails, they have waived the privilege as to everything else, and I would note, they did not do anything to satisfy the New York Times standards. That's the decision cited in our brief. It is their burden to satisfy those standards. They did not show that they acted promptly. They did not show that they did anything. They didn't even show that they had reasonable standards in place, protocols in place for this type of thing not to happen. And we cite decisions in our case. That's the Enterprise Architectural Sales,
So,
Lilco. Thank you, Your Honor.
thank you. Panza versus RXR Church Division Tower.
Good afternoon, Your Honors. May it please the Court. Beth Gehrig on behalf of the appellants. I'm aware of the volume of case law coming from this department, which says that an unwitnessed accident does not prevent the plaintiff from attaining summary judgment. But there's a caveat to that. And the caveat is that when there is evidence contradicting her version of the accident or bringing
What evidence contradicted?
her version of the accident, we have the testimony from her coworker.
Hazel?
Yes. Now,
Who says, I am aware. That sounds like hearsay to me.
Absolutely.
She does not say, I saw. She says, I am aware. That's not a personal observation that this court can consider.
What you're looking at, Your Honor, is her observation as to how the accident occurred. What we're looking at is her observation as to the mechanical piece of equipment that was involved in the accident.
Is she an expert?
No, but she knows the difference between a dumpster.
I'm sorry. No.
Your Honor, there's a difference between a dumpster and the A-frame cart. Let's put that aside for
This record, okay? You have 4 people saying we were there when the plaintiff says there was no one there.
We're not saying that they were there to see the accident. We're there to say that they're there to see the aftermath. If I may, Your Honor, let's say, for example, a car accident happens. Okay? Nobody sees the car accident. The cop comes to the scene. The plaintiff says, I was driving my BMW and I was in a horrible accident. The cop doesn't see the accident. The cop arrives at the scene and sees she's driving an old jalopy. His observation as to the equipment.
Well, that he could observe. But in her affirmation or affidavit, the witness that you're talking about, she does say, I was aware, I was aware that she filed this lawsuit, whatever. I mean, we have a picture of the piece of equipment that the plaintiff alleges she was pushing, which is, I agree, that would not be a dumpster. That's called an A-frame, I don't know, something, cart. And then there is some reference to a dumpster. So, I mean, it seems that so they could testify about what they each saw. It seems to me that's an issue of fact because they're disputed as to what's going on here.
Exactly, and that's why the plaintiff should not have received summary judgment. We're not asking that the case get dismissed. We're just asking that we get to go to a jury. And it's not just about,
based on what?
Based on exactly what Justice Kaepernick just pointed out. The fact that the witness who came to the scene immediately afterwards sees the piece of equipment that was involved that had to be righted was not the A-frame cart. Let's go to another piece of evidence that we submitted to you.
Who testified that it was a dumpster?
It was the affidavit from the witness.
Interesting.
Oh.
And who was there afterwards.
The crux of your case, and we don't have an EBT of anyone who says that under oath. We have an affirmation.
However,
that doesn't get tested.
Your Honor, however, that is raising an issue. In fact, it's just a credibility issue.
No. She says, she doesn't say, she says, she was not present and she was aware that she had been pushing a debris container.
She also says that she helped her write it, and what they were helping her write was the debris container. But I'm willing to move past that. Let's instead go to the expert affidavit. And as they say, pictures paint 1,000 worlds.
The expert who didn't,
Who never saw
he
the.
never saw anything.
The expert took measurements. The expert was there. The expert took her testimony. He took measurements of the hallway. They know the measurements. If she was pulling the A-frame cart, I'd ask you to please look at pages 114 to 116 of the record, where there are pictures showing plaintiff pushing, the akin of pushing the A-frame cart with the sheetrock on it. So if she's pushing the sheetrock cart, as she says, she's pushing it down, it's leaning to the right, she's behind it on the right, and she encounters something which stops the front right tire. Okay, that's going to cause it to go up.
Oh, you know what?
It flips to
I'm
the right.
sorry. We had the case of Touré versus HFZ 11 Beach Street. I was on it. The exact same thing happened to the plaintiff in that case with an A-frame and 16 cement boards on it. So it happens. But you'll have time on rebuttal, counsel.
May it please the court.
Let me ask you, what do you make of this? If we agree that her coworker said it wasn't the A-frame, it was a mini dumpster, what relevance does that have to your summary judgment motion?
I don't think it has any when she points to the picture of an exemplar, and at record page 943, that's the picture. She says, that's it. When
Well, her
during-
coworker says that's not it. Oh, although we don't know, because she does, right? Doesn't
She
say,
wasn't
I looked at that exemplar, that wasn't what she was, though all she says, I was aware it was a mini dumpster. I don't know, I don't even know.
Well, call it a mini dumpster, call it an A-frame cart. I know they're two different
They
things.
sound like very, I mean, I have the picture, that does not look like what I would call a mini dumpster, but, you know. But that looks like an A-frame
That's an
cart.
A-frame.
You know, that's not a dumpster, and we know what a dumpster is.
Yeah.
And she pointed right to it and said, that's what I was pushing. And there's
But what
no-
about the coworker saying, I helped her put the debris into the mini dumpster?
Right.
She also says she wasn't there at the time of the accident. In fact, nobody was. She also says, well, I picked her up. She was laughing. It's, you know,
Right.
she didn't really get hurt.
She picked what up?
She picked the cart up,
Which Miss Pezo refers to as the mini
the
dumpster.
mini dumpster. That's correct. And that's in an accident report that was written by someone who didn't witness the accident based on someone else who didn't witness the accident.
How long after?
How long after, yeah?
One was then and one was a few months later, right?
Months, yes, months after the fact, Your Honor. So to Judge Manzanet's point, this is the Torre case. This is the Sansino case. This is the Marrero case, all of which involved plaintiffs that were pushing some kind of cart or mini vehicle with wheels.
Now, here the issue is, I'm correct that your client was asked to move these pieces of sheetrock by her supervisor, correct?
That's correct.
And so at the end of the day, the question is, did they provide her with the proper equipment to move it?
And the answer to that is no. That's Torre, and that's Sansino, precisely for that reason. And by the way, she
So
does.
that even if we were to believe that she was made to move this sheetrock on the mini dumpster, they didn't provide her with the right equipment to move the material.
Then the mini dumpster is what fell. She wasn't provided with a safety device to prevent it from falling. The sheetrock falls on her anyway. So whether you call it a mini cart, an A-frame cart, a mini dumpster, whatever it is, the device fell on her because it was inadequate to provide safety for her. The question regarding the expert, well, not only does he ignore all of the other record evidence that doesn't fit within his conclusion, but he doesn't base his conclusion on anything other than it's impossible for it to have happened that way. What do you base that on? What's the study? What's the authority for that? So based on those,
He didn't conduct any simulation test in this hallway that he measured to see if it could tip over this.
if he did, it's not in his report. Okay. So clearly, we believe that the lower court got this right based on both 240 and 241.6. There's no question that Industrial Code 23-1.7 E1 and E2 really fit here. This was a passageway. This was a work area. This was a floor. The cart came into contact with debris, which is the objects that those two Industrial Code sections deal with, and there's no question that the piece of debris was not integral to the work. All we have to do is look at Rusich to say, hey, it wasn't. What's the quote? It wasn't inherent to the task at hand and not avoidable without obstructing the work or imperiling the work.
Thank you.
Thank you.
So you reserved 2 minutes.
Your Honors, I think it's important to remember that here it was the plaintiff who moved for summary judgment. So if plaintiff is moving for summary judgment, the facts are to be viewed in the light most favorable to the party opposing summary judgment. I'm not saying, again, that his case gets dismissed, her case gets dismissed.
I'm trying to figure out what is the so there is a dispute as to what they're calling what the sheets were in. That doesn't go to the fact that she's the only one who was there at the accident. She testifies the accident occurred. And all the other things that you raised, like she was laughing afterwards, it goes to her damages, which you're still having a damage trial. So I'm not really clear why you think there's an issue here.
It's not an issue as to what it's called. It's an issue as to what it was. Plaintiff herself describes the difference between the debris container and the A-frame cart.
What has that got to do with the fact that she testified indisputably that the sheets fell on her and no one disputed that?
Because if she was pushing the debris container, then she was not pushing the sheetrock. That's the whole thing here. If she was using a different piece of equipment and not telling us what was actually happening at the time, and instead she was pushing a debris container, which was one of her jobs. She said that 4 to 5 times a day, she would go around and she would pick up.
Yes, but her testimony was that she was asked by her supervisor to move sheetrock to different locations throughout the day. And that was what she was doing at the time. And I don't remember seeing any testimony or affidavit from her supervisor saying anything different.
However, we do have the affidavit from the witness who said she asked for my help in picking up the debris container. If it's the debris container, it's a closed garbage can, a metal garbage can. Therefore, the sheetrock would not have been on it. She would have just been collecting the debris, which is what she typically did. And if you look at using all the measurements that our expert looked at, he didn't pull this out of a hat. He looked at the measurements and the testimony that was in the record.
You're out of time. And measurements of a hallway? Yes. We're supposed to extrapolate from that this is physically impossible?
When the hallway is 5 feet wide based on his measurements, and the sheetrock, which plaintiff testifies, is 8, she said, the size of a door. The smallest type of sheetrock is 4 feet by 8 feet wide. She says it's horizontally on the cart. She says it hits on the top right-hand side. She claims it goes to the right, and even though she's to the left, it somehow goes over to the left when it's weighing this way. He explains that this is impossible.
Earlier you said she was on the right, but it's okay. We've got the record and we've got the briefs. Thank you. Panza versus, oh no, that's the one we just did. Park versus Sakosa. Sorry, I'm just mangling these names. No offense intended. How do you say it? Sakosa. Oh, I really messed that up. Okay.
It seems close, Your Honor.
You may proceed.
Good afternoon, Your Honors. May it please the court. My name is Nina Oxman, and I represent the appellants herein. The instant action presents this court with the question of the symmetry of the parties and causes of action, as well as the damages sought herein. It is respectfully submitted that there is a lack of symmetry between the parties and between the causes of action as required by CPLR 3211.
We don't really need symmetry, right? We need like substantial identity of the parties and the underlying facts or claims, right?
Sure.
It's not pure symmetry.
It's not pure symmetry.
We have some
but
wiggle room.
There's some wiggle room. But however, in this case, there is a party missing from the first action. Teresa Chong, who is the wife and a manager at the clinic, that is the question herein.
I thought she only worked at the clinic for a very short time when her husband had some medical issues or some reason that he wasn't able to work there. And I'm not even sure she really has standing in this case. So what's the problem if she's
It's
not
actually
in
a
all the
fact that
cases?
was overlooked by the lower court. She was working as a manager in the clinic before the defendant was laid off and before, like, while these events were occurring. She's also the wife of the doctor who invested his personal money based on statements made by the defendant manager who was laid off. There is a check which comes from their joint personal account that is an issue herein, and it's not an issue in the prior case. Also, she did work from 2016 to 2019 in the clinic. So there is...
How many cases do there have to be between these parties in the court to deal with these issues? I mean, they're not that complicated, but there's, what, 3 cases going on? Why is...
About wasting judicial resources.
Well, in that case, Your Honor, there is a case which we did cite to in the underlying papers where there is, there's some commonalities here, absolutely and admittedly, but there are enough, there's additional party and there's additional causes of action and damages that shouldn't be thrown out here. So there is a case where the court...
What is the additional causes of action?
There's an intentional tort, and there's also a breach of contract in
Why can't you just move to amend the pleadings and the actions that are pending now?
Well, I'm not sure why they didn't do that, but if the
Well,
court
that's
decides that in
exactly
this-
right. Why bring a third lawsuit? Why not just go in on the ones you already have? So you're not prejudiced. You can go in and make whatever claims you want. And even at the end of a trial, you could move to conform the pleadings to the proof, right?
Your Honor, if that, they would be prejudiced. I believe we're getting close to the statute of limitations here, so if there is some sort of decision on that, I hope it would be without prejudice to amending the other action. There is a case where the actions could be consolidated. In 11 East 68th Street, there was a similar situation. The court consolidated the actions there. They did not dismiss because the parties were lacking in symmetry, but this way, Appellant Chong's claims would be preserved, the additional causes of action would be preserved, the additional claims. There were also facts in the case that came to light later after the original cases were litigated.
So you amend your pleadings. I mean, you don't say, oh, let me bring another lawsuit. I mean, I know the parties are angry at each other. I get it, but I don't think I'm concerned that the way to respond to that may not be, let's bring another action because the courts don't have enough things to do.
Understood, Your Honor. However, in this case, the symmetry could have been, or rather the issues here could have been resolved by consolidation rather than dismissal completely, and that would have also preserved judicial time and effort. So I would end here, and if you have any additional questions. We did ask to consolidate in the lower motion. I don't think it was formally moved for. We mentioned this case. We asked that it would be consolidated.
Counsel, if
and
you
the
don't
court,
formally
I mean, you just mentioned it.
what are we doing? Practicing law on the fly?
Under CPLR 3211A4, the court does have the ability to decide what is proper in these circumstances.
but the
consolidation would have been
It's
proper.
nice when there is a available relief that you can ask for, documented on paper, so it's preserved for appeal.
It was documented
It's
and
called-
asked for.
All right, thank you.
Thank you.
Good afternoon, Your Honors. Russell Moriarty from Levine and Blitt. May it please the court. When two substantially similar, and that's the important language, actions are brought, the court should dismiss the second action.
Is there a problem? She raised one of the issues being that the doctor's wife, Ms. Teresa Chong, was not named in the other actions. So that seemed to be the big point because she started off with that. And I wondered if you could address that.
Certainly don't believe that's a problem here, Your Honor. Two things about that. One, she's the plaintiff's wife in the first case. They could have brought her in if they wanted to at that point. More importantly, paragraph 22 of the complaint basically lays out the only allegations related to Ms. Chong in the 2024 case, and those are just that Ms. Sakosa, the respondent, committed her financial improprieties, failed to pay vendors, failed to pay staff, and that caused conflict in the office. That's the only allegation related to Ms. Chang. So I don't see that allegation justifying an entirely different case and separate case being brought. So, I want to address 11 East 68th Street because, and I'll point out that was the only case cited by appellants in their brief to stand for the proposition that this second lawsuit should survive. And that case is totally different than what happened here. In that case, Party A sued Party B, and then Party B turned around and sued Party A. Over the same transaction, yes, but two separate lawsuits, one suing the other sues back. In this case, Party A sued Party B. Party B brought counterclaims in the first case. Then Party B used those counterclaims to file another suit against Party A, totally different than the only case cited by the appellants. And I don't believe that case justifies this second action as well. The subject matter of both cases are exactly the same. No question. They involve respondents' employment, allegations of financial improprieties, allegations of not paying staff, and allegations of holding yourself out as the owner. Same exact allegations. The causes of action are very similar, and I'll admit there was some creativity in the second action. They took what they considered to be respondents' misconduct in their employment and turned that into a breach of contract allegation, I'm sorry. But for the same conduct, they just called it breach of action in the second action.
Is consolidation a fairer disposition than dismissal of this action?
I don't think so, Your Honor. And again, there's no legal support for that. The case cited by appellant to support or in which consolidation was the outcome was totally different than what happened here.
Well, unlike the other grounds in 3211A, 4 gives the court some discretion to craft an appropriate remedy. It's not dismissal or nothing. The court does have some discretion there in determining whether dismissal is appropriate or some remedy short of that.
And that's exactly right, Your Honor. And the law does say, though, if the actions are substantially similar, they don't have to be exact, dismissal is warranted. And here, like the court acknowledged, the first counterclaims could have been amended to add the very small few details that ended up in the second case, or the wife of the defendant counterclaimant in the first case. So we believe that that was the appropriate way that this case should have been settled.
Counsel expressed some concern about being barred now in terms of her time to consolidate. Is that so?
Would they be barred? I would imagine that would be a possibility. But the fact is,
if that is a possibility, wouldn't the result of consolidation rather than dismissal then be more appropriate?
no, because the second case never should have been brought in the first case. The lower court got it right. It's a waste of judicial resources, and it could have led to different outcomes for the same issues. So no, we believe
Which is why consolidation is better.
No, I don't think so.
Right.
I don't think so. The party already wasted the court's time by bringing a case that never should have been brought under the law. That's our position.
All right, thank you. You have a minute.
Thank you, Your Honor. I just want to make 2 points. Ms. Chong, the plaintiff who was not included in the first case, she has claims, respondent claims that there's only one allegation, and that's not correct. She has claims based on the fact that she was working there before 2016 to she was working there in 2016 to 2019 before the manager was laid off.
What is her claim? What's Ms. Chong's claim?
She has claims related to intentional tort. She has claims.
Intentional what? Yeah, what is it?
That the actions that the manager took, which were numerous, and some of them were added in the second complaint, added together to an intention to defraud and hurt the both the wife and the doctor.
Duplicative of the claim that already exists.
It's not fully litigated in the underlying
Fraud whom?
earlier action. Sorry?
Fraud whom?
Defraud the doctor and his wife,
that's not-
and Ms.
how
Chong.
You mean, like, it's like an embezzlement, or it's money, or they were taking money? Isn't that what
Yes.
they were taking money, they held themselves out?
They took money from the clinic, and they also, there is a check which he issued from their personal account of him and Ms. Chong, the doctor, based on allegations that were made by Ms. Sakosa.
Well, couldn't the
By
damage
fraudulent statements about them needing the money because there was no money left in the clinic.
So
which she had
I
taken that
mean,
money.
if his name is on the check, he can get the entirety of the check back.
Well,
right?
she was
He
also
doesn't need-
injured
He
under
doesn't
this.
need Ms. Chong, right?
I would say he does, I respectfully. And there is a.
So much. Your
Thank
time
you.
is up. Have a wonderful evening. Wagner versus Wagner. You may proceed.
May it please the court, Eric Panza for appellant. In denying summary judgment declaring the will of trust terminated, the IAS court made three fundamental errors. The first two concern the termination provisions of the will of trust agreement, whereas the third concerns the prenuptial agreement entered into between Leah.
Don't these agreements, in my reading of these agreements, they seem to be somewhat contradictory. And that's one of the problems I have in trying to determine whether you're entitled to summary judgment when it's not clear what their agreements were, because they had a lot of agreements that I think say different things.
Justice Kapnick, let me say that these agreements are not contradictory when you look at them in context. The trust agreement is not a marital
Which
agreement.
trust agreement? The
Willett
trust agreement? Okay.
says these are the beneficiaries, these are the dispositive provisions, and these are the termination provisions. The beneficiaries take their interests subject to those provisions. You can't take the benefits without the detriments. The prenuptial agreement has different parties. It's not between the trustee, okay? It's between husband and to-be and wife to-be a year later, and it says we define separate property as follows, and we do it not in the vernacular separate property as in yours and mine, separate property within the ambit of DRL 236B. It specifically says that. Now, what does that mean? I didn't know. I'm not a matrimonial lawyer. I'm a teeny lawyer. Well, I looked it up. That means that one of the parties is not going to claim equitable distribution of that item. So what Leon is promising in the prenuptial agreement, he made good on. He's not claiming equitable distribution. He's saying if you have this asset when we get divorced, and there's no guarantee you're going to have it, nor is there any guarantee that I, Leon, are going to have any of the assets on my schedule. What happens if I lose them during the marriage? There's no guarantee you're going to have them. But if you do have them, they're yours on the divorce.
But I thought that
distribution.
I thought that the intention that Mr. Wagner indicated was that he wanted to make a provision for Lisa's children, and even if they weren't together, he wanted to make.
Well, who said that?
Well,
that's only in Lisa's affidavit. There's no competent evidence that the agreement says what it says. And it says Lisa's the beneficiary, as are her children, but it also has a termination provision. Listen, I'm providing for you and your children, but if we get divorced, and if you sue me for rights in addition to what you get here, then this is.
But she's not getting what is there. So why shouldn't she be allowed? I'm talking
sorry,
now.
Judge. Yes.
Why should she not be allowed to contest that? You said that was mine, and now I want it.
Because she would be getting that had she not brought the additional lawsuit. It's not this lawsuit. It's the lawsuit where she sued Leon for breach of an alleged oral agreement that the couple would cohabitate in Puerto Rico, that she sought additional rights and benefits as a result of their relationship. Had she not done that, and had they still got divorced, the trust would not have terminated. She and her children would have still had the benefit.
Except, let me just say this, counsel, it doesn't just say separate property. It says that separate property would be treated as if the parties had no relationship whatsoever. That's a different thing than separate property under the DRL. So there you go.
Well,
that is, I own this property as if you and I never had a relationship. The trust agreement is based on their relationship. So that is I think, pretty straightforward.
Judge, what
Let her finish talking, please.
Straightforward conflict that can't be resolved on a motion for summary judgment.
Respectfully, Judge, I disagree for this reason. A year after, when the parties entered into the prenup, Leon had no interest in those assets. They were funded into the trust. They were irrevocably gifted to the trust.
When
and
were
there
they
was attached-
funded in the trust?
A year before, when the year.
So they were in the trust already when the parties agreed that that property would be treated as if they had no, because they signed a prenup that says that property would be treated as if they had no relationship whatsoever.
Respectfully,
I'm
Judge,
reading
that's
it.
incorrect. They were funded into a trust a year before that agreement.
Exactly.
And so if Leon, let's assume that's correct. Let's assume that in the separation agreement, Leon made some egregious misrepresentation as to these assets. That's between Leon and Lisa. She may well have a remedy against him. And the matrimonial court is well equipped to give her that remedy. That you can't touch the trust assets because Leon doesn't own them anymore. But the matrimonial court could, through equitable distribution, make things equal between Leon and Lisa.
No, your argument was that this is subject to the DRL, which says that all it means is it can't be distributed in equitable distribution. I'm telling you that your agreement says something else, something different, not just DRL separate property. That's separate property under the DRL. Because you didn't have to put in would be treated as if the parties had no relationship whatsoever. That's not in the DRL at all.
Counsel,
It's not our agreement.
I need this to not be a debate just between the two of you. You are addressing this court.
Yes, I
okay?
am, Judge. I'm answering
Please.
a question.
All right, and
If you'd like me to answer it, I will. If not, I'll sit down.
go ahead. Finish your thought.
Judge, this is not our agreement. This was an agreement entered into by Leon and Lisa. I don't represent Lisa. I represent Leon. I represent the trustee. It was entered into a year after Leon no longer had ownership of these assets. You cannot give away respectfully what you don't have. Had Leon said in this agreement, I'm giving you my interest in the Brooklyn Bridge, he didn't have it. She may have a remedy against him. That's all fine and good. The trustee has nothing to do with that. It's not against the trustee.
Thank you.
Thank you.
Good afternoon, may it please the court. Annette Hasapides for the respondent, Lisa Wagner. I'd point out that Leon Wagner has made no appearance on this appeal. His attorney only proffered a hearsay affirmation below. Leon's statements would go a long way to demonstrating what went on here, which is why the court properly denied summary judgment.
Well, you know, Mr. Panza said when I asked a question that it was only based on an affidavit from Lisa, but I have it here. Mr. Wagner has a certified letter in the record in which he says, now this was in May 2012, so that was before they got married and before the prenuptial agreement, that he is planning to make certain provisions, letter to Lisa, for you and your children to ensure you are provided for in the event that I die or become incompetent while we are in a committed relationship or our relationship ends. So there was an intention in 2012 to do that.
Yes, I'm agreeing with you that that's what the letter said.
Yeah.
But the contention that he could have promised this as her separate property and then do whatever he wanted with it throughout the pendency of the marriage flies in the face of the law. Counsel in the reply brief at pages 9, 17, and 19 cited to and relied upon DRL 236b5 and Van Kipnis. But in both of those instances, Van Kipnis court cited to DRL 236b5, which says that separate property shall remain as such. Remain. It means once it becomes separate property, it remains separate property. So the reliance on Van Kipnis and DRL 236b5 makes no sense. Once he promised it to her as her separate property, it was hers to do with. And Judge Scarpulli, you cited to the page 115 of the agreement, that really corroborates that and confirms that. If we held otherwise, then what would happen? In this case, my client waived and forfeited substantial equitable distribution rights, maintenance, inheritance rights. This man was worth $181 million. My client had nothing at the time they signed the prenup.
I'm sorry to interrupt you, but if I understood your friend correctly, he's not disagreeing that you may have a remedy, it's just the remedy isn't against the Leon Wagner 2011 trust.
Well, but that's why we have questions of fact, because it is her separate property. Leon Wagner has an agreement with my client that the Willett Trust assets became her separate property. They've acknowledged by even addressing it in their summary judgment motion that this conflicts with the trust agreement, and that's why we cannot grant summary judgment. As we argued below, this is either the product of fraud or mutual mistake, but we cannot allow the assets to be dissipated by disgorging them back to the trust when we have clear evidence that my client relied to her detriment on the promises made in the prenuptial agreement. Once it was defined as separate property in the agreement, it became hers. It did not become hers if it was still available at the time of the divorce, because can we imagine the results?
That's not consideration for anything.
Exactly, Your Honor. Unless the court has other questions, I would point out that they did not make out their prima facie burden. Their summary judgment motion consisted of nothing more than the trust agreement, the trust agreements, the prenup agreements, including the letter, Judge Kapnick, that you referenced, and the attorney affirmations of the Wagner trustee beneficiaries, which were hearsay, and simply said, we agree with everything that Move-In's counsel said. And same is true for Leon Wagner, his attorney, who drafted the prenup and probably could have provided some documentation concerning the meaning of these terms in light of the trust agreement, and further attempted to contradict Ms. Wagner's representations at 276 to 278 that she was unaware that there was the possibility that the Willett Trust assets could be disgorged back in the event of a divorce. And finally, I just would like to address the fact that there are questions of fact whether or not her commencement of litigation constituted additional property rights as a result of the relationship. The agreement was signed before they were married. What did that mean? As a result of the relationship, when they are simply a paramours, gave her nothing. So at the time they signed that agreement, what would any litigation that she could have commenced as a result of the relationship mean? It's undefined, it makes no sense in the setting of when it was originally signed, and it raises more questions.
That wasn't a contract. He was giving her something, so it doesn't matter that I find that a difficult argument because it wasn't, she didn't have to give consideration for him to give her children property in a trust. So it seems pretty straightforward, the same way when you say in a will, if you contest this will, you're not getting any money, the property is going back to me. That seems like a pretty straightforward, although it contradicts the later.
Right, and Your Honor, what she sued on was not as a result of the relationship. He made a separate promise to her. It was not a promise that he was obligated, that it's not an additional property right that she was entitled to as a result of them being husband and wife, the litigation that she commenced. So it was not as a result of, it was despite the relationship.
In Puerto Rico because he liked her to be in the...
But again, it depends on how you define the relationship. I see my time is up, and I thank you, Your Honor.
Thank you.
I don't know how best to use my 2 minutes, but let me just say that Leon has not appeared in this proceeding, and the reason is it has nothing to do with him. This is a dispute, although it was, in our view, improperly thrown into the matrimonial. This is a dispute between two trustees. When Leon and Lisa got married, when Leon and Lisa executed the prenup, Leon had no interest in these assets. He could have promised her the Brooklyn Bridge. She could have a claim against him. Not our issue. I don't represent him. I represent the trustee.
You're saying Leon had no interest in what assets?
In the Willett Trust assets. He funded them into the trust, irrevocably put them in the trust, filed tax returns. There was
including the artwork?
Well, the artwork he had an independent interest in. He'd owned half of those. Half of them was put in the trust, and the parties entered into agreement as to what would happen, what kind of
round robin.
But the assets that he owned solely, those were all put in the trust. He had no interest in those.
You mean the apartments?
That's right. No interest, and you have the language of the Wagner trustee.
I'm sorry, the man interrupts you just for a second and ask you, what happened to the assets if she commenced the lawsuit?
if they broke up, they're not in a committed relationship.
That happened.
And if she commenced a lawsuit seeking additional property.
What happened to the assets?
The assets go to a different trust that Leon created for his children.
And who's the trustee of that trust?
His brother's a trustee.
And who's the
That's my
beneficiary?
client.
That's your client.
That's my client. That's
And his children are the beneficiaries
correct.
of that. So he has an indirect beneficiary
No, he has no,
relationship with it, right?
Judge, I would respectfully dispute that. There's no, the interest in wanting your kids to have money, I suppose, just as the will.
That's a big one.
Well, yes, but
Every
it's not
parent
illegal.
has that one. That is the guiding light of every parent
It's not
who
a
is
reason-
responsible. So, I mean,
Well, no, they're of age. He's not responsible, and it's not a legally cognizable interest, Judge. The same way the Willett trustee is Lisa's brother, okay? And he puts in papers saying, yes, I received all the assets. They're mine. They're not Leon's. So we're talking here about a perceived dispute between agreements when one party, when he signed it, he had no interest to give away. That's the problem with this. That's why the lower court got it wrong.
you got your argument.
Thank you, Judge.
Rooney versus Board of Managers. You may proceed.
Thank you, Your Honors. May it please the Court, Manu Davidson on behalf of the defendant's appellants, Boyd, Richards, Parker, Colinelli. We're here today asking the Court to reverse a motion for an order denying a motion for partial summary judgment concerning discrimination and retaliation claims. First, I'd like to, if I may, address the plaintiff's contention that the appeal is untimely. It is timely. The notice of entry was filed on October 21, 2024. The notice of appeal was filed on November 20, 2024, 30 days later. The plaintiff's contention is that the 30-day clock to file the notice of appeal ran on one of 2 days. First, when the appellants, my clients, filed the transcript of the proceedings before the trial court. The second, when the plaintiffs made a cross motion concerning discovery. The first argument is our position does not hold water because the trial court specifically instructed the plaintiffs to file a notice of entry with, I think it was 10 days of the appellants filing the transcript. That never happened. The plaintiffs or the respondents acknowledge that we filed that transcript, but they don't address the fact that they didn't follow the court's directive. The second argument, Your Honors, is a lot. The plaintiffs are saying, well, we made a cross motion, and so therefore that's the notice of entry.
No, that's not a notice of entry.
So, Your Honors, based on that, again, we just want to make sure that that issue is addressed. CPLR 5513 specifically says that the time to take an appeal as of right must be taken within 30 days after service by a party upon the appellant of a copy of the judgment or order appealed from and written notice of its entry, except that when the appellant has served a copy of the judgment or order and written notice of entry, the appeal must be taken within 30 days. My clients were the appellants, filed the notice of appeal within 30 days, et cetera.
Okay, why don't you get to the substantive issue?
Thank you, Your Honors. Turning to the substance, there's a disagreement in terms of what this case is about. Our client's position is it concerns alteration agreements, the plaintiffs doing work that wasn't approved. The plaintiff's position is, well, the way that the board addressed these issues is discrimination, is retaliation. At all times, the plaintiffs had the burden of demonstrating that they were the victims of discrimination, retaliation, et cetera. The crux of the plaintiff's claims are really subjective beliefs, speculation, conclusory assertions. Somebody called me an imbecile. Somebody said to shove it up my...
Nobody wants to be called an imbecile.
I understand, but
right?
that in and of itself...
And it's a derogatory statement about an individual that you are a fellow board member with. So those statements certainly can at least suggest some animus that should be explored.
Animus, It's more than that, Your Honor. It has to be a demonstration that
Well, she did give us more than that. She talked about how her alteration agreements, the things she was required to do, no other non-Hispanic had to do, right? And that's her allegation.
I understand, Your Honor, that's her allegation.
So,
but
and certainly if that is proven, that would go towards showing discrimination.
a subjective belief, speculation, stray remarks, even if they are rude, does not rise to the level of discrimination.
But that's not a stray remark. That's a potentially expensive, disparate treatment. And obviously, nobody's ever going to, or no, actually, people do.
Yeah.
But I think we all recognize that discrimination can come in less obvious ways. And one of the ways that I think discrimination can be shown is I was caused to have to pay $20,000 more for my renovations than any other person. Did you put in evidence to disprove that allegation?
The evidence, Your Honor, as I understand it, part of the issue concerning the
Well,
alteration.
I'm just asking. That's her allegation. She's a part of a protected class, and she says, here's what I've got, one thing. What did you put in to show either that wasn't true or that there was a legitimate discriminatory reason for that disparate treatment?
The treatment, as I understand it, Your Honor, concerned in part the fact that the plaintiff's contractors cut a heat riser pipe, which caused some damage, common elements, apartment below. That issue then became a very different issue than just a straightforward alteration, right? The plaintiffs then had to go through, they acknowledged they needed to fix it. They didn't like the way that the board approached the requirement that they fixed it, right? The board wanted to have inspections done. Nothing wrong with
And
having
use
inspections
use sheetrock that nobody else was required to use, right? Because right, so it's not like there's nothing
More
there.
expensive. Half an inch versus the larger, there's a huge price differential in that.
There may be, Your Honor.
And that's okay if the board requires everyone to use it. But if you single her out and all of the alterations for their apartments, then we have a problem, and then there is an indicia of discrimination. But you will have time on rebuttal.
Thank you, Your Honors.
Thank you, Your Honors. May it please the Court, Mark H. Bierman for the respondents, plaintiffs. I just want to briefly address this timeliness issue. Yes, there was the order, and mea culpa, I thought I had filed it, but the question here is whether they were on notice that triggered.
No, the issue is the court ordered you to file a notice of entry. That's it. You have to do it. Period. It's not, oh, does he know? We know he knows because, as you said in your papers, they submitted documents about it. So I get it. They knew. But that is not the test. Once the court requires you, directs you to file a notice of entry, you must do it because that clock doesn't begin to run until you do.
Well, I'll just say briefly, I don't want to belabor it, but I think.
Yeah, I just want you to have enough time for the real meat of the argument.
So
okay?
I'll move on. We've addressed it in our papers, Your
Can
Honor.
I
And I just want to
ask
say
you-
briefly, I'm sorry.
May I ask you about the retaliation claim? What is it that you're claiming? What specifically are you claiming happened in retaliation for the claims of discrimination?
So after this nightmare that my clients went through, I sent a 7-page letter on October 3rd of 2008 detailing all of the discriminatory actions that we thought in great detail, single-spaced. After that, things got even worse. As bad as they were, that's when they started saying, you got to replace branch lines that nobody had to replace.
So they came after that letter that you wrote.
You have to bust open the wall. You have to pay $12,000 in legal fees. You have to pay additional deposits. You have to pay additional fees. I mean, it was unbelievable.
When did you start this action? 2009? This is a 17-year-old case?
Yes, this began in 2009. It's been a long haul.
So.
I mean, you can see there's, I just want to say that if you, as the court would observe, the judge below, Justice Schumacher was exactly right. This was the most threadbare motion that I've been practicing 45 years. This was like, you have a statement of facts that has a few little statements about what my client said in a record with thousands of pages. There's no affidavits of the defendants. They don't even point there, thousands of pages of transcript testimony, basically not denying what my clients had said. I did, and you know, maybe it was a little overboard, but there was so much here. I did 811 paragraphs of facts that supported our claims that they didn't respond to. They didn't reply to. All they submitted was a memorandum of law, a brief memorandum of law. They gave no justifications. They didn't show that there was no evidentiary root. They didn't show that there was that they had good excuses for all of the things that we were alleging. The only thing that they even slightly implied was because the person who had marketing experience that they chose over my client on the board, when they don't even, it's not really a justification. They just say that's what they told her, that it was marketing experience.
What are they
And she had been there 15
There's no marketing
years.
experience.
I mean, are there a bunch of apartments available that they need to sell, that they needed a marketing expert in order to beef up their board?
First of all,
seems that somebody who works for a company that makes repairs to buildings, now that would be somebody who would be really helpful on a board.
which is my client's experience, who worked in an architectural office. The other person who was non-Hispanic Caucasian, who had been in the building for a year, worked for a commercial marketing firm that not even involving real estate. This condo was established in 1984. There were no units to sell. The condo had no involvement.
Well, at least this makes out your claims. I mean, you're not winning here, you're just continuing your case here, right? They are moved for summary judgment to prove, and so the burden was on them.
Burden was on them, and they showed nothing, which is exactly what Justice Schumacher said. They didn't lay bare their proof, and then they showed none of the things that Bennett and all the other cases have said you got to show. First, in your motion for summary judgment, before we have to do anything.
Right.
Nevertheless, you know, we submitted enormous amounts of evidence as to what had been going on for 5 years and how my clients were being treated in the context of people who were saying, we want them out of the building. And they did the same thing to the only other Hispanic member of the board who was also driven off the board. I mean, you know, coincidence, ladies and gentlemen? I mean, this was, there was no explanation for this. They just said, well, she resigned. Well, she resigned because my client said she was railroaded off the board. I mean, this is the kind of behavior. They don't even say why, when they forced my client off the board when she was duly elected, that they ignored the bylaws, which required them to meet. They had to have on notice, have a majority vote saying we're going to hold a unit holder vote, hold a unit owner vote, and then have the unit owners remove the person that they put on the board. They didn't even do it. They just stopped letting her participate on the board, saying she resigned when they knew she said she hadn't resigned. After they, in an incredibly abusive conversation, screamed at her to the point where she was having heart palpitations and shaking. This was the kind of treatment that they experienced over 5 years. I mean, quite extraordinary. All the other things, the way the constantly intrusive inspections about whether they had carpeting. Then when they said, why don't you look at the other units? All the other units, and the testimony is they were all owned by non-Hispanic Caucasians. When they finally gave in after my clients begged them to do this, they found none of them were in compliance, including the guy who was complaining, and then they never enforced the rule against any of those people. I mean, that this was a summary judgment motion to me is extraordinary. Thank you, Your Honors.
You have 2 minutes, counsel.
Your Honor, just a couple of things. Mr. Atkins testified concerning Mariela Schwartz. She is the other board member who was alleged to be Hispanic on the board. Mr. Atkins was, I believe, at the time he came onto the board, he learned about this litigation, he investigated the complaints, he spoke with Ms. Schwartz. Ms. Schwartz was appalled by the notion that somebody accused the board of being discriminatory. She left the board not because she was discriminated against, but because she thought it was a waste of her time. That's the evidence in the case. Record at 869. The complaints concerning Mr. Pugh, these were inter-unit owner disputes. Mr. Pugh was annoyed by the fact that he was hearing noises. He was annoyed by the fact that the board wasn't giving him enough attention concerning the noise dispute. The Brunies were disappointed by the fact that the board wasn't doing enough. What the record shows, Your Honors, is that these are interpersonal disputes. People didn't like each other, but that doesn't mean that there's discrimination here. And I would like to point your...
But council said that it was more than that. The council said that the board inspected their apartments, but not the other apartments until they insisted on it. They were in compliance and the other tenants weren't.
The evidence in the
Did you
case...
dispute that?
The evidence in the case is that Mr. Pugh, I believe, requested an inspection. An inspection was performed. An inspection was also requested by the Brunies of the surrounding apartments. The evidence also is, according to the managing agent...
Was that done?
Yes.
Okay.
And according to the
Were they in compliance?
as I understand it, they weren't, according to the record.
And did you order them to bring in carpeting like you did the Brunies?
Well, according to the manager...
Were they? This is a really simple question. Either they were or they weren't.
The answer is no, because there were no other complaints concerning the surrounding units, right? So the only complaint that was coming from, concerning the noise, concerning Mr. Pugh, was coming from the apartment above the Brunies, not the surrounding apartments. That's the evidence in the case. I'd like to point, Your Honors, again...
We're out of time. Thank you.
Thank you, Your Honor.
You've got your record.